All right, good afternoon. It's not quite 4 o'clock, but it looks to me as though we have everyone that we need. I'm checking on that right now. I have that. All right, that was a little strange. We're live streaming on YouTube and it was giving me feedback from myself. Could you all hear that? That's okay. We're going to figure this out together. So it appears my name is Katie Konechny and I'm the ruling judge. And I see that we have James Nibbs and I believe Sue Chandler are our scoring jurors. And I believe I see them on here as well. And so I know we're just a few minutes early, but since it looks like everybody is here, I'd like to get started if we can.
Excuse me, Your Honor.
What's that? I'm sorry, go ahead.
Apologies, sorry. I think we're missing one of the witnesses.
Okay, well then let's just give it a couple minutes. Thank you for letting me know.
All right.
My pen is low, so I'm gonna grab another.
For the missing witness, it says the meeting host will let her in soon. So if somebody is the host here, please let her on in.
Oh, there we are. Thank you. All right. I think we might have everyone now. So before we begin, informally, can someone let me know if we have all necessary parties present?
Your Honor, it seems as if all the witnesses are present and a counsel.
Okay. In that case, then we are here for round one of the 2020 Summit Cup. If I can please get an entry of appearances from the attorneys, beginning with the plaintiff.
Good afternoon, Your Honor. CJ Bauer with Esther Veloz, and together we have the privilege to represent Cam Donaldson, the plaintiff. Pending introductions from opposing counsel, Your Honor, we have a brief summary of the case that we have prepared, housekeeping issues, and 3 motions for the court.
Okay. And I see, Mr. Bauer, you are Team Pikes Peak, is that correct?
Yes, Your Honor.
Well, that makes it easy. Pikes Peak and plaintiff, lots of P's. All right. And entry from the defense, please.
Good afternoon, Your Honor. My name is John Hobbs, representing Ms. Karen Basia in today's case. I'll let my co-counsel introduce himself.
Okay.
Good afternoon, Your Honor. Matthew Nunez, representing defendant Karen Basia. She's also sitting with us at counsel's table.
Okay, great. And what is your, not your school, but do you have a team identifier?
Well, Cameron. Cameron.
All right. Mr. Is it Nibbs, is that correct? Or Ms. Chandler, do either of you have a conflict with any of the students or advocates in this round that we need to be aware of?
Judge, I do not have any conflicts.
Great.
I do not have any conflicts.
Excellent. Are both of you prepared to proceed then this afternoon?
Yes.
Yes, Your Honor.
Okay, great. In that case, I'm going to swear all of the advocates in, please. If you could please raise your right hand and indicate by saying "I do" if you swear to abide by the rules of this proceeding and conduct yourself in a manner that is honorable to this forum.
I do.
I do.
Thank you.
I do.
All right, in that case, we will now call case number 2008 CR 2263, Cam Donaldson versus Karen Baja. I will turn first to the plaintiff. You stated that you had some kind of preliminary matters you'd like to take up. I'd like to do those before any substantive motions in limine, please.
Yes, Your Honor. We have prepared a brief summary of the case if you would like.
Sure.
This is a wrongful death case in which the plaintiff, Cam Donaldson, alleges that the defendant, Karen Basia, killed Lou Donaldson. Lou Donaldson was Cam Donaldson's father and the defendant's husband. The plaintiff alleges that Karen Basia killed Lou Donaldson, forged his will, and took all of his money.
Okay.
That concludes the summary of the case, Your Honor. We have some housekeeping matters that we would like to address.
That's fine.
For the purposes of today's trial, may we argue sidebars constructively?
Yes, we can do sidebars constructively. I'd still like to limit those to when appropriate, but we want our scoring panelists to observe those as well.
Would Your Honor like to swear in the witnesses? Shall we swear in the witnesses, or shall we presume them sworn in?
We'll presume them constructively sworn.
May we use exhibits during opening statements?
If you have a good faith basis to utilize something, I don't have an issue with that, though of course the opposing counsel is free to object if they believe that there is not a good faith basis that it will be admitted in testimony. So yes, but there could always be an objection.
Yes, Your Honor. This is something we had talked about pre-trial, and defense counsel noted some concerns. That is why I brought it in front of the court.
Okay, well, if we know exactly what it is, we might as well just take it up now so that we don't have to deal with this in an opening. What is the exhibit? If you want to tell me what it is, and then I'll turn to defense about what the objection is. Yes,
Your Honor. The slideshow that would be used during opening contains 4 exhibits. The exhibit 004, what's been marked as exhibit 004. Would Your Honor like me to describe the exhibit?
Yeah, please.
It is a lock. Exhibit 005, a picture of the back gate at Wild Wildlife. The jury, the wrongful death instructions, the 4 elements would also be presented during this. And exhibit 003, the picture of Cam Donaldson and her father, Lou Donaldson.
Okay. And defense, you have some concerns about these in opening?
Yes, Your Honor. Our main concern is the fact of using evidence that has not been actually entered into the record. Our fears are that it will go to confuse the jury and thus violate federal rules of evidence 403, being substantially more prejudicial than it is probative.
Okay. Is there an exhibit in particular that you're concerned would not be admitted?
Your Honor, our concerns were actually okay with the exhibits themselves coming in during the trial. Our concerns were if they would be used during the opening before they're actually admitted.
Okay. It doesn't sound like these are hotly contested exhibits, and so I'm going to authorize them to be utilized in opening. My larger concern is elements being utilized prior to everyone agreeing on the jury instructions. Do the parties stipulate that the 4 elements of a wrongful death suit, do we stipulate to those contained within the jury instructions that we have right now?
Yes, Your Honor, that has been stipulated in the problem.
Is that true, Mr. Hobbs?
Yes, Your Honor.
Okay, then I know that wasn't your concern, it was just one of mine. So I'm going to allow the plaintiff to utilize those exhibits and the elements given the record made.
Your Honor, does this jurisdiction follow the 1 advocate, 1 voice rule?
Yes, if it is your witness on direct examination or cross-examination, that's the only advocate that shall object, if that's the question.
Yes.
Yes.
Pursuant to the rules of this jurisdiction, we may not redact documents during trial. If this does come up during trial that a document may need to be redacted, redacted. May we constructively redact these documents?
That's fine.
For impeachment purposes, would Your Honor like us to share the page of the deposition or report on the screen, or shall we presume that the witness has a copy of their deposition?
I don't know. I think we'll just have to see how it goes.
And at this time, the plaintiff would like to constructively invoke the rule of sequestration under Federal Rule of Evidence 615.
Did you wish to have any party representatives?
The plaintiff, Cam Donaldson.
Okay. Obviously, the defendant would not be sequestered. Does the defense have any other party representative that they wish to have as an advisory witness?
Your Honor, yes, we would like to have the expert, Chris Renard, present during the trial. He
Okay.
was hired to investigate Lou Donaldson's the insurance policy around Lou Donaldson. He is already familiar with the facts of this case and can adapt the facts of the trial to his testimony as an expert witness. And thus we argue that he should not be sequestered.
Okay. Any objection to that, Mr. Bauer?
No, Your Honor.
In that case, all witnesses with the exception of the plaintiff, the defendant, and the defense expert. What was the name again, Mr. Hobbs? I'm sorry.
Chris Renard.
Oh, yes, Mr. Renard. Shall be sequestered. Any final preliminary matters besides that, Mr. Bauer?
No, Your Honor, that concludes our housekeeping matters.
Okay. And before we get to motions, are there any other final housekeeping or preliminary matters from the defense?
Yes, Your Honor. Due to the limitations of doing this trial over Zoom, we would like to inform the court that my co-counsel and I will be communicating through private chat through our cell phones.
And my understanding is that that's authorized. So I don't have a problem with that. Is that your understanding too, Mr. Bauer?
Yes, I just think Mr. Hobbs was bringing it up so it doesn't look like they're distracted. We completely agree. We'll be doing the same thing.
Okay, understood.
Yes, and one more housekeeping matter, Your Honor.
Sure.
Again, due to limitations of doing this over Zoom, my co-counsel and I have a 2-camera setup just to bring it to the court's attention. So if you see us moving up, it's just we're getting to position for the second camera.
Okay, that's no problem. And I don't know if any of the pretrial rulings address this. And so apologies if it does, because we can utilize the pretrial rulings. But one other option for your witnesses reference, as well as myself and Mr. Nibbs and Ms. Chandler, is I have an electronic copy of all exhibits that I can refer to as an electronic trial notebook. And so if you have something else arranged just because of the unusual format, please don't let me change it. But if you need to utilize a reference to an electronic page number, that's okay with me as well. So I know, again, this is kind of a new forum. If there's something else prescribed or something that you're planning to do, there's no obligation to utilize the electronic trial notebook, but it's an option if you'd like it. Although I say that, and I don't know if Mr. Nibbs and Ms. Chandler have it. And so do you know, Mr. Nibbs, were you given an electronic copy of the case file?
I was not, Your Honor.
Okay, well then let's disregard that last statement, and we can utilize screen sharing for purposes in this forum, and understanding as well that we can make sure that the jury's not constructively seeing something they shouldn't. That's not a concern of mine right now, given the forum.
Thank you, Your Honor.
Thank you. All right, and did you say that was it for housekeeping, Mr. Hobbs?
Yes, Your Honor.
All right. I know that took a little longer than normal. I figured it might just because of new formats. With that, I assume we might have some substantive motions in limine as well. I'll turn to the plaintiff, please.
Your Honor, the plaintiff seeks to exclude any fact, evidence, or testimony related to Lou Donaldson's character. Lou Donaldson is the deceased in this matter. It was known that Lou Donaldson would fly out of the country without giving his family any notice. He was a secretive and private man. Under Federal Rule of Evidence 404A1, we seek to exclude this evidence as character evidence is inadmissible in a civil trial. We anticipate that the defense will elicit this evidence to show that Lou Donaldson flew out of the country just before his alleged disappearance and that it was normal for him to do so.
I'm sorry, so you're stating you want to move to exclude evidence that it was common for him to leave the country without notifying people?
Yes, Your Honor.
Okay. And from the defense?
Yes, Your Honor, we seek to admit and elicit this type of testimony. It is permissible under Federal Rules of Evidence 405 as reputation evidence. Furthermore, we seek to elicit this testimony pursuant to Federal Rules of Evidence 404B, B2, to show motive, lack of accident, and intent.
Can you respond specifically to the 404A1 for me, please, Mr. Hobbs?
Yes, Your Honor. This will not be used for propensity purposes. Again, this will go to show Lou Donaldson's character, which is as reputation, which is permissible under Federal Rules of Evidence 405. Furthermore, Your Honor, it's the plaintiff's burden today to show that this theory that Lou Donaldson did leave was less likely than whatever theory they are proposing.
Okay. Response to that, Ms. Veloz?
Your Honor, under, in a civil trial, character evidence is inadmissible. Lou Donaldson's motive, intent, and lack of accident, it's not an issue in this case. And I stand by my argument that character evidence is inadmissible in a civil trial and therefore should not be admitted.
Now, there are permissible purposes for this type of evidence pursuant to 404A1. Is that right, Ms. Veloz?
Yes, Your Honor, that there are. Now, character evidence could be in a specific act that a person did in the past or reputation evidence. Under I believe it's 404B, that says you could use it for intent, motive, lack of accident, but the intent of Lou Donaldson is not an issue in this case, Your Honor, and neither is the lack of accident. Therefore, it should be inadmissible.
Okay. I think I disagree that Mr. Donaldson's intent is not at issue, because my understanding is that, frankly, it's debated whether or not he is in fact still alive, if I understand the defense theory. And so I'm going to deny the motion at this time. I think I'd like to hear a little bit more about this reputation to make sure the foundation is sufficient, but I don't believe that there's grounds to exclude it at this point. So I'm going to deny that motion.
Your Honor, the plaintiff seeks to exclude any fact, evidence, or testimony related to conversations between Chris Renard and his contacts at the Pioneer Police Department. Chris Renard is the expert witness in the defense's case. The contents of what Chris Renard learned are inadmissible as under Federal Rule of Evidence 802 as inadmissible hearsay. The plaintiff anticipates that the defense will this testimony, even for the truth of the matter asserted, if I may proffer the information that Chris Renard learned, Your Honor.
Sure.
He learned that Ms. Basia was not a suspect in the case. There was no signs of foul play or blood. And although this may be relevant, it is an out-of-court state. He learned it through out-of-court statements, and it is inadmissible as hearsay, Your Honor.
And tell me what the statement is one more time. I'm sorry.
There wasn't no specific statement made, but these conversations occurred via the telephone, Your Honor. Therefore, he learned it through a conversation. He also did not learn this information directly and officially from the Pioneer Police Department. He learned all of this information, essentially cutting corners and talking to a friend that he had at the Pioneer Police Department after the police department refused to give him any information.
Response from defense.
Yes, Your Honor. We do not seek to elicit the specific statements between Chris Renard and work at the Pioneer Sheriff's Office. However, we do seek to elicit that conversations did happen, and that would go to the basis of our expert's opinion which is permissible pursuant to Rule 703.
Okay, but are you intending to maybe we don't have a specific statement, but will Investigator Renard specifically state like there wasn't any reason to think there was foul play and things like that?
One moment, Your Honor. Yes, Your Honor. Mr. Renard will discuss how the conversation affected his expert opinion in his report, which is, again, permissible as an expert under 703.
Okay. Any response to the 703, Ms. Veloz, the Rule 703?
Your Honor, as an expert witness, Chris Renard can rely on otherwise inadmissible evidence. However, she can't testify, she can't testify about the inadmissible evidence and essentially become a backdoor in getting hearsay information into trial, Your Honor. The only way it would come in if the probative value substantially, in helping the jury substantially evaluate the expert's opinion, would outweigh the prejudicial effects. That's not what's happening here, Your Honor. The information is inadmissible hearsay. It should not be admitted for the truth of the matter asserted, and its probative value is not substantially outweighed by its prejudicial effect, Your Honor. Therefore, if Chris Renard decides to testify that he relied on this information and that he had a conversation with the police, we could stipulate that those conversations did happen. However, we would not be in agreement with letting the actual information come out through Chris Renard's testimony, Your Honor.
Well, I agree that 703 is the governing law here. It's hard for me to know how probative this information is in a vacuum versus the prejudicial effect. And so I'm going to deny the motion at this time, but I think it's appropriate to re-raise it during trial, just because, again, I think analyzing its probative value right now is too challenging for the court. So I'll deny for now and encourage you to re-raise that objection timely.
Your Honor, just to clarify, when this testimony comes up, would you like a warning from counsel?
Yeah, if you want to approach beforehand to let me know, that'd be great. Thank you for asking, Mr. Nunez.
And Your Honor, in an effort to expedite any evidentiary issue, since we do expect it to arise, the plaintiff seeks to admit the maintenance report created by the Pioneer Police Department regarding Carl Bannister's tracker and his police cruiser. Carl Bannister is an unavailable witness in this case, and we seek to include this evidence under Federal Rule of Evidence 8036, as it is a record kept in the regular course of business and therefore not hearsay.
Okay. What exhibit number is this?
It is exhibit 0017, Your Honor.
17, okay. For the defense?
Yes, Your Honor, we seek to keep this report out of the record. There are two layers of hearsay, both the record itself and the statements from Chris Renard, which are hearsay without exception.
And what about the 8036 argument from the plaintiff?
Again, that only addresses one layer of hearsay. There is a hearsay statement within this document itself, the report from Chris Renard that his patrol vehicle detection system was not working on August 18th. This is a second layer of hearsay, which is still unaddressed and has no exception.
Okay. And what about the other layer of hearsay, Ms. Flose? How do you respond to that?
Your Honor, we are not seeking to read any statements from the report out loud. We only seek to admit the report so that the jury could look at it once they're in deliberation.
It doesn't, I'm sorry to interrupt you. If it's admitted in evidence, it doesn't matter if it's read to the jury or they have it, so.
Right, so the evidence, the exhibit comes in through Carl Bannister's, statement. In this jurisdiction, it was already authenticated. Additionally, Your Honor, under Federal Rule of Evidence 8036, it is a business record. Kept in the regular course of business, and it should be admitted. If it does not come in, Your Honor, the testimony that we seek to admit would also, could potentially come in through Carl Bannister's deposition, which we also plan to read in.
Okay. I don't feel comfortable admitting something without hearing the foundation when there's an objection, so I'm going to have to deny that at this time.
Nothing further from the plaintiff, Your Honor.
Great, thank you. Motions limine from defense?
Yes, Your Honor. By way of background, this is a wrongful death action brought by the plaintiff against his stepmother with regards to the disappearance of his father. Defense anticipates that the plaintiff will seek to admit a statement made by a man called Exotic Bob. The statements they wish to bring in will be statements with regards to my client Karen Baja threatening him, as well as her admitting to killing her husband. These statements are hearsay within hearsay, so defense moves to preclude on those grounds. Additionally, Bob Exotic is in prison. The statement was not made under oath, and those statements did not have a chance to be cross-examined.
Response from the plaintiff.
Your Honor, the statement made by Exotic Bob was made in the presence of a court reporter, and is also signed by the court reporter, attesting that all the statement was true and accurate. Additionally, Your Honor, this is not hearsay within hearsay Federal Rule of Evidence 805. Exotic Bob testified to a statement made by the defendant herself. It wasn't something that he learned through someone else and then talked about it. It was a personal conversation between Exotic Bob and the defendant under Federal Rule of Evidence 801 D2A. It's a party opponent admission, and therefore it's non-statutory hearsay, Your Honor, and should be admitted for the truth of the matter asserted.
And is this in the form of a video, is that correct?
It is, Your Honor, and we also have the transcript.
Okay. It's my understanding too that the parties stipulated that Exotic Bob is an official pursuant to 804A, is that correct?
Yes, Your Honor.
I'm going to deny that motion based on the stipulation regarding his unavailability. And then of course, and I know it's not your argument, Mr. Nunez, that Ms. Baja is a party opponent. I will agree that with the plaintiff that this evidence is admissible.
Your Honor, if I may be heard.
Sure.
The second layer of hearsay has not been remedied. Sure, there's a party opponent statement, but then the statement itself in the document is hearsay that cannot be admissible.
And I'm sorry, correct me if I'm wrong. I thought Mr. Exotic Bob's unavailability answered that. Am I misunderstanding, Mr. Nunez? It's fine if I am.
One moment, Your Honor, to confer with co-counsel.
Sure.
Your Honor, I would just like the record to reflect that Cam Donaldson is a female. Mr. Nunez had referred to Cam Donaldson as a he.
No problem.
Your Honor, plaintiff's counsel is referring to the unavailability under Federal Rules of Evidence 804A. They still need to remedy the 804B exception.
Okay, I'll let Ms. Willis have one more word on that, on what exception under 804B specifically applies.
Your Honor, under 804B3, I believe. B3. The statements within the statement, the statements within the transcript as well as the video are statements that Exotic Bob made against his penal interest. In the video, Exotic Bob talks about an illegal deal that he had with the defendant. although Exotic Bob is in prison because of a civil case brought against him by the defendant. Therefore, the statements of an illegal deal still puts him at risk of criminal charges for illegally importing large cats, leopards, tigers, and such. Therefore, it is admissible under 804(b)(3).
Any final response to the statement against interest, Mr. Nunez?
Yeah, Your Honor, there's not a statement against this party's interest as he's already in prison. And at the moment that my client, Karen Baja, states that she would do something, he's completely cut off from that interest, from that part. Excuse me, from that interest.
I think it does open him up to a potential either criminal or civil liability. And so I'm going to stick with my original ruling, deny the motion, and find that the recording from Exotic Bob, the statement is admissible, including the statements Ms. Baja made. Any further motions from the defense?
No, Your Honor.
Okay. Is there anything we need to get to before we get to opening statements? Anything from the plaintiff?
No, Your Honor.
Anything from defense?
No, Your Honor.
Give me just 2 minutes. My evidence book is downstairs and I want to have it for the remainder of this, so I'm not also looking at the rules of evidence on my computer. Give me 2 seconds and we'll get started. All right, my apologies. If we everything is concluded, we'll go ahead and start with opening statements from the plaintiff.
Yes, Your Honor.
I'm sorry. Can I just clarify on the last motion in limine ruling?
Sure.
I think we were talking about different statements. I think plaintiff was trying to elicit testimony with regards to the moving of illegal animals while the defense moved to preclude the statements made saying the threat towards Bob Exotic and her admitting that she killed her husband in a certain way.
Okay. And
I'm saying her statements don't go against Exotic Bob's penal interest. So those statements should be redacted from the record.
okay. My understanding is that, and I understand that we can constructively redact things, is that those statements that Exotic Bob, it's contained within the same transcript in the same video where the statement about illegal selling of cats is. Is that right?
Yes, Your Honor.
Okay. And your position is that like those individual sentences that Ms. Baja allegedly made to Mr. Bob should be excluded or redacted from that portion?
Yes, Your Honor.
Okay. Because those particular statements are not against his interest.
Yes, Your Honor.
Okay. I understand that. And I think it's probably a valid argument, but I know redactions, particularly in a video, are going to be challenging right now. And I think it's a good argument. But I'm going to just stick with my original ruling at this point and err on the side of admission. I think it goes to weight. And I think it's a good issue on appeal for your client.
Yes, Your Honor.
All right. Let's get to openings. Thank you.
Patient like a tiger, the defendant sank her claws into Lou Donaldson and never let go. This case is about Karen Basia and Lou Donaldson, and the evidence will show that Karen Basia killed Lou Donaldson, forged his will, and took all of his money, leaving Cam Donaldson, the plaintiff, with nothing. This starts when Karen Basia first met Lou Donaldson. She was all alone walking down the side of the road. She had nothing. And Lou Donaldson stopped to help Karen Basia. She saw her way out of her situation. She saw a man with money. And Karen Basia was instantly attached to Lou Donaldson. Karen Basia sank her claws deeper and deeper into Lou Donaldson until she ripped him away from his family. Lou Donaldson divorced his wife and married Karen Basia. She now had a comfort and a lifestyle that she always wanted, because Lou Donaldson gave Karen Basia everything. She began working at Wild Wild Life, a company that Lou Donaldson and his family built from the ground up into $1 million business. It was like a fairy tale. Until one day, Lou Donaldson told Karen Basia that he wanted a divorce. And the evidence will show that Lou Donaldson didn't feel safe around Karen Basia because she had threatened to kill him. And after years of marriage, Karen Basia felt that lottery ticket, Lou Donaldson, slipping through her fingers. And in one August weekend of 2012, Karen Basia sank her claws so deep into Lou Donaldson that he's never been seen or heard from again. Now let's go back to that August 2012 weekend and look at the days to better understand the bigger picture. August 17, 2012 was the last day that Lou Donaldson was ever seen alive. Now on that day, it was a Friday afternoon and he was leaving work. His daughter, Cam Donaldson, was there, who had been his assistant for over 20 years. And Lou was leaving the office and told Cam, "I'll see you back on Monday morning." And it was that Friday night or early Saturday morning, August 18th at around 3 a.m. when Karen Basia, the defendant, was broken down on the side of the road. The defendant didn't call her husband for help. She called Carl Bannister, her brother. Now, Carl Bannister is a Pioneer County Sheriff's deputy. From the moment Carl Bannister clocks in at 12 a.m. to the moment he clocks out at 8 a.m., every movement that he makes is recorded by a GPS unit. But that night, from around 3 a.m. till around 6:30 a.m., his car didn't record where he was. Malfunction. And it was that Saturday, August 18th, or Sunday, August 19th, 2012, that Karen Basia began telling everyone Lou Donaldson's missing. Sunday, August 19th, 2012, as the sun is still coming up over Pioneer County, the alarm goes off at the Wild Wild Life office. Cam Donaldson, the plaintiff, wakes up and rushes over to Wild Wild Life. And as she's pulling into Wild Wild Life with the police blazing a trail behind her, she sees the defendant. She sees the defendant walk out of Wild Wild Life with a random person carrying lock cutters. Now, Cam Donaldson found out that the lock to the front gate of the Wild Wild Life office had been cut. She later learned that the back gate to the Wild Wild Life office was destroyed, cut, shattered. The evidence will show that the defendant was carrying a lockbox. And that lockbox was taken from Cam Donaldson's desk. And inside of that lockbox was Lou Donaldson's original will. A will that split everything that Lou Donaldson had 4 ways. That's not the will we will see here in this case. That lockbox was never seen again. The original will was never seen again. Days went by, weeks went by, and Lou Donaldson was still missing. Now, after a few weeks of Lou Donaldson missing, Karen Basia showed up to the Donaldson home where Cam and her mother Loretta were. And she showed them a will, a new will. And this will gave everything to Karen Basia. Everything that Lou Donaldson owned was given to Karen Bastia. And this will is dated June 14th, 2012. And this is important because, as we will come to find out, on June 12th, 2012, Lou Donaldson filed a request for temporary restraining order against Karen Bastia. And the evidence will show he filed that because he was scared of Karen Bastia, because she had threatened to kill him, and because he wanted to divorce Karen Bastia. And on the 5-year anniversary of Lou Donaldson's disappearance, the defendant had Lou Donaldson declared legally dead. She had Lou Donaldson declared legally dead so she could collect his life insurance policy of $5 million. Cam Donaldson, during this course of 5 years, was still hoping that her father would come home. But when the defendant did this, Cam Donaldson knew exactly what happened to her father. And as the plaintiff, we have brought this case. We have brought this case because of the defendant's actions. And because of that, the plaintiff has a burden. The burden is preponderance of the evidence, more likely than not. And we must prove by a preponderance of the evidence 4 things. 1, that Lou Donaldson is dead. 2nd, that the death of Lou Donaldson was caused by the defendant's intentional or reckless conduct. 3rd, that the plaintiff, Cam Donaldson, suffered injuries, damages, or losses as a result of the death of her father. 4th, that the defendant's conduct, either intentional or reckless, was the cause of Cam Donaldson's injuries and damages. During the course of this trial, we're going to hear evidence and see testimony that would support what we must prove to you. We're going to hear from Cam Donaldson. Now, Cam Donaldson was Lou Donaldson's only child and his best friend. This is a person who has spent over 8 years without their father. And Cam is going to tell us how her father's disappearance has changed her life. And we're going to hear about the last weekend that Lou Donaldson was seen alive, because Cam Donaldson is going to walk us back through that August 2012 weekend. Then we're going to hear from Taylor Pride. Taylor Pride is an investigator and document examiner with over 20 years of experience. And Taylor Pride is going to tell us about a 3-step process that he uses in every case that he has. The 3-step process that he used in this case to determine that Lou Donaldson did not sign that will, that the will was a forgery. And Taylor Pride is also going to talk about the investigation he conducted into Lou Donaldson's death. Then we're going to hear from Exotic Bob. Now, Exotic Bob isn't going to be live on your Zoom screen today, but we're going to be sharing a video to you. And what Exotic Bob has to say in this video is important. Exotic Bob is going to be talking from his jail cell. And from that cell, he's going to tell us that the defendant was in his office, looked him in the eyes, and told him, "I'll do to you exactly as I did to my husband. I'll feed you to the kitties just like I did him." And then we're going to hear from Chris Renard. Chris Renard works for Summit Life Insurance Company. He's worked for Summit Life Insurance Company for over 20 years. This is important because Summit Life Insurance Company is the same company that paid the defendant Lou Donaldson's $5 million life insurance policy. Chris Renard's worked for this company for...
I'm sorry, I don't normally do this, but the plaintiff doesn't, excuse us, the defendant, we don't have a burden today. We are not required to put on the case. The burden rests and remains with the plaintiff. For him to testify about what evidence and what witnesses we are calling is highly inappropriate.
The court will advise that the defense does not have a burden in this case. You can continue, Mr. Bauer.
And we're going to hear from Chris Renard. Now, Chris Renard's worked for Summit Life Insurance Company for over 20 years. And during that course of time, at Summit Life Insurance Company, the company that paid Karen Bastia the $5 million life insurance policy, Chris Renard has reviewed hundreds of wills. And he'll tell us that he has never seen a will with the phrase, "if I should die or disappear." And Chris Renard is also going to tell us that despite all of his years working at Summit Life Insurance Company, he can't determine if Lou Donaldson actually signed that will. Then we're going to hear from the defendant, the woman whom the evidence will show killed her husband, put him in a meat grinder, forged his will, and took all of his money. Now, at the end of this trial, once you've heard all of the testimony and seen all of the evidence, we are confident that you will find the defendant liable for the wrongful death of Lou Donaldson because she sank her claws into him and never let go. Thank you, Your Honor.
All right. Thank you, Mr. Bauer. Opening from the defense, please.
Yes, Your Honor, a moment to set up.
Please.
Permission to proceed.
You may.
A girl is walking along the road. It's the middle of the night somewhere here in Statesville. At only 17 years old, this child doesn't have much. She doesn't come from money or status. She has nothing as she walks along this dark road. And she's getting scared. As she continues to walk along this dark road, she's approached by a stranger 20 years her senior, and a stranger who offers her a ride. So with little option, Karen Baggia accepts a ride from the stranger, Lou Donaldson. It was this chance meeting that brought Lou and Karen together. Their connection that kept them together for as long as it did. Karen's hard work that helped build up their dream career. But now Lou is gone. And as Ms. Baggia has finally found some semblance of closure, she's being dragged into court and accused of having something to do with Lou's disappearance. But if you just listen to plaintiff's opening, you can already see that all there is to their case is the plaintiff's grief, an emotional plea, and speculation.
Objection argumentative.
I'll overrule for now.
An emotional plea and speculation. Perhaps it's understandable. The plaintiff loved his father too, and now he needs answers, someone to blame for Lou's sudden disappearance. But however understandable the plaintiff's pain is, it is not enough to prove their case today. There is no body, there is no proof, so there will be no liability. Good evening. My name is John Hobbs. I, along with my co-counsel, Matthew Nunez, represent Ms. Karen Baggia, the defendant in today's case. Today, the plaintiff has a burden to prove to you by preponderance of the evidence that it is more likely than not that Karen Baggia caused Lou Donaldson's wrongful death. And they will fail to meet that burden today because past all the speculation, rumors, and emotional pleas, you will see that there is no body to prove that Lou is dead and no proof showing that Karen Baggia caused his death. Now I want to take a moment to tell you more about Karen and Lou's life together. You'll see that 8 years ago, Karen lost her husband, and every day since, she has worked to keep their dream alive. Karen met Lou by chance. A connection formed, a connection strong enough to build up the Wild Wildlife Big Cat Emporium. You see, this emporium was the culmination of Karen and Lou's passion for preserving and protecting endangered species of big cats. This wasn't a lottery ticket. This wasn't just another day job or a gig. This was Karen's life. A life she shared with her husband, a life she loved, a life she had to work to maintain. But while this connection was strong enough to bring Karen and Lou together, you will see that it wasn't strong enough to keep them together. Their marriage wasn't perfect. Lou Donaldson's family never accepted Karen. You will see that she was never accepted because she didn't come from money. So to Lou's family, she wasn't worthy of Lou and his wealth. You will see that to Lou's family, they could never forgive what they saw as the street trash that ruined Lou's previous marriage. I'm
sorry, Mr. Hobbs. I'm going to sustain the argumentative objection on that last point.
I want you to remember that when you hear the plaintiff's case today. You will see that Lou's family was the only challenge Karen faced. Prior to his disappearance, Lou became secretive. He was a pilot who would disappear, fly off, without telling Karen where he was going or when he was coming back. He was a pilot, and I want you to pay attention to the testimony about his planes. Pay attention to the testimony about his pilot's license. Pay attention to the testimony about how secretive he was about his flying. Pay attention and you will see that through all of that, Karen still wanted to work things out. She wanted to remain by Lou, even though he continued to disappear and leave her to take care of the emporium all by herself. And you will see today that that is what happened in August 2012. You will know this because no other testimony will tell you otherwise. You won't learn how Lou died. You won't hear any testimony about where he died, where he was the days leading up to his disappearance. You won't see any pictures of his alleged death. Moreover, members of the jury, you won't learn how Lou allegedly died, his cause of death. You won't see a single lead from the plaintiff's investigation connecting Miss Baja to Lou Donaldson's disappearance. You won't see a single sign of a struggle that they collected during their 3-year investigation. You won't see anything more that's more than a rumor. As we begin today's trial, I want to remind you of something. Each of you were chosen because you made a solemn oath. An oath to not let pity or emotion cloud your judgment. An oath to base your decision on the facts and whatever proof the plaintiff can bring you. So at the end of today's trial, my co-counsel will come before you and ask that you return the only verdict that's permitted by the evidence, not guilty. Thank you.
Thank you, Mr. Hobbs. The plaintiff, ready to call your first witness?
Yes, Your Honor. One moment to prepare my screen.
Sure.
Plaintiff calls Cam Donaldson. Good evening. Please introduce yourself to the jury.
Hi, I'm Cam Donaldson.
Where do you live?
I live right here in Pioneer County. I've lived here my entire life.
What do you do for work?
Anything I can find. Ever since my dad passed away, I've been doing different things because I was fired from my job at Wild Wildlife after he went missing.
What is Wild Wildlife?
Wild Wildlife is a big cat sanctuary where we take care of lions, tigers, and leopards.
How long did you work there?
For over 20 years. It would have been 30 years now if Karen never fired me.
How did you get the job?
My dad hired me.
What's your dad's name?
He was Lou Donaldson.
And what did he hire you to do?
I was his assistant, so I did it all. I scheduled meetings, I wrote checks, I answered phones, ordered supplies, and I ran the books. And I also had access to all of his bank accounts. We used to even joke that I knew the business better than he did.
Do you still have access to these bank accounts?
Not anymore, but I have records of his accounts and they haven't been touched since he disappeared.
I want to go back to your relationship with your father. Were you guys close?
We were super close. I loved my dad. He was my best friend.
What did he do for work?
My dad was a true businessman. He was a used car salesman. He bought and sold planes, and when he made enough money, he opened up Wild Wildlife.
Do you know why your dad opened up Wild Wildlife?
Yes, because animals were his true passion, and he wanted to make sure to protect them.
Growing up, how was your parents' relationship?
My parents were best friends, and all of us were really close.
Tell us more about your family.
Well, Wild Wildlife was like our family business. My dad started it, and we all worked there together. It was some of the best memories that I have until Karen came along and everything changed.
Who is Karen?
Karen's the woman that my dad married after my mom.
How did things change when the defendant came along?
Well, Wild Wildlife wasn't a family business anymore. I wasn't even that close with Karen.
What was your relationship like with the defendant?
It wasn't good. My dad and I were super close, and then Karen came into the picture and was manipulating my dad.
How was that?
Well, I knew she just married my dad for his money, which led to a lot of problems in their relationship.
What problems are you referring to?
Objection.
And what's the basis of the objection?
outside the presence of the jury, she's speculating on the last response.
And I believe the response, and since we're outside the presence of the jury, is something along the lines of she was trying to get my dad's money, something along those lines. Can you please repeat that? What that answer was, Mr. Bauer?
Yes, I believe Ms. Donaldson said that she was speaking towards how Ms. Basia was manipulating her father, and that it was her belief that she was after her dad for his money.
I agree that that's speculation. I'm going to sustain that objection.
May I briefly respond, Your Honor?
You can.
This is information that Cam Donaldson formed over the years of knowing Karen Basia and the close relationship which she had with her father. This is her personal opinion of seeing this relationship up close.
I think you need to lay more foundation for that. So I'll give you a chance to lay that foundation. I realize the length of the relationship has been established, but to state that she was after money, I think there needs to be something a little bit more solid foundation. So I'm going to sustain for now and give you that opportunity.
Your Honor, I just moved to strike that testimony.
That's fine for now, but again, I'm going to give him the opportunity to lay the foundation.
How long did you know the defendant? How long have you known the defendant?
I've known her for over 20 years.
And how do you know her?
She married my father, so I also worked with her at Wild Wild Life.
And tell us about their relationship specifically.
Well, they had a lot of problems in their relationship.
And what do you mean problems?
Well, one time things got so bad that my dad tried to get a restraining order. And after that, there was one night, like 2 weeks before my dad disappeared, that I overheard Karen and him arguing.
Now, if you could turn to page 55 of the packet and look at what's been marked as Exhibit 0016, Ms. Donaldson, and let me know when you get there.
I'm there.
Do you recognize this signature? Do you recognize this signature?
Yes, I do.
How do you recognize this signature?
It's my father's signature.
How do you recognize your father's signature?
Because I've seen it over 100 times as his assistant.
And is this a fair and accurate representation of your father's signature?
Yes, it is.
Your Honor, plaintiff moves what has been marked as Exhibit 0016 into evidence as Plaintiff's Exhibit 1.
For ease, I'm going to refer to these as the exhibits just as they're marked. So any objection to exhibit, and I understand plaintiff would be 1 and defense would be A, but just for ease, any objection to exhibit 16, Mr. Nunez?
Yes, Your Honor. This witness is not an expert in signature comparison or knowledge. For her to admit this through a signature there's a lack of foundation. Additionally, this document has hearsay within it.
Let me say this. As it relates to the signature, I find she's familiar with her father's signature. You can certainly cross-examine her on that. It doesn't require expert testimony. She's familiar with it. She's laid sufficient foundation for that. I don't know what's contained within the rest of the document besides the signature. Is there something else on it other than a signature, Mr. Bauer?
Yes, Your Honor. May we go sidebar so I can share my screen and show you the document?
Sure, thank you.
Just one moment. Your Honor, are you able to see my screen?
Yes.
Now, this is the request for temporary restraining order that Lou Donaldson sought against the defendant. Here we have a public record, so this would fall under exception 803.15. Further, the statements contained therein, numbers 1, 2, and 3, are evidence of the then existing emotional condition of Lou Donaldson on January 12th, 2012, when this document was filed. Would Your Honor like me to go more in depth on that?
No, I'll hear a response from the defense as it relates to this being public record and the hearsay response for then existing mental state.
Your Honor, as long as this is not being used for the truth of the matter it asserts and solely for the Lou Donaldson's belief, and it comes with a limiting instruction, then there's no problem, Your Honor.
Do you consent to that, Mr. Bauer?
Your Honor, we would like the document in its entirety to come in.
My understanding is if something qualifies under a hearsay exception, it doesn't require any type of limiting instruction, though I don't believe they'd be able to argue it, outside of the purpose that's being admitted. to show his state of mind, though I somewhat doubt the plaintiff would be doing that. So I'm going to overrule the objection. I'll admit Exhibit 16 pursuant to 8033, as well as authentication for the signature.
Your Honor, just a point of order to clarify, the exhibits will be entered in as they are marked.
I think it makes it a little easier. I'm fine with that if the parties are okay with it.
I just have one moment to adjust my notes here.
If you want to go with the number it's admitted, that's fine too.
Permission to share my screen with the jury, Your Honor?
You may.
Cam, do you know why your father needed a restraining order?
Yes, because Karen threatened to kill him when he asked for a divorce.
You mentioned an argument that your father and Karen Basia had. When was this?
It was early August of 2012.
Where did this happen?
It happened at the office at Wild Wild Life. Karen and my dad were in another room, and I could overhear them arguing, and that's when my dad told Karen that he wanted a divorce.
Were you in the room at that time?
No, I was right outside of it, and it was very loud.
Did you ever go into that room?
No, Karen stormed out of the room, and my dad walked out right after her, and he was very visibly shaken up.
When your father was visibly shaken up, how soon after did you talk to him?
The second he left that room.
And when you talked to your father, the second he left that room and he was visibly shaken up, what did he say to you?
Objection. Calls for hearsay.
Response?
Yes, Your Honor, we have laid the foundation under Federal Evidence 8032 for the excited utterance exception to hearsay.
I agree. Overruled.
Your Honor, if I may be heard,
Okay.
can I just have a proffer of what this witness will say?
Sure. If outside the presence of the jury, Mr. Bauer.
Yes, we intend that Ms. Donaldson will say something along the lines that her father told her that if anything ever happens to him, to have the police look into Karen Basia.
All right. Mr. Nunez, based on that?
Yes, Your Honor. This testimony is irrelevant as it is speculative. She's testifying as to what may happen in the future, and the prejudicial value substantially outweighs the probative value. Should the jury hear this, it cannot be unheard, and the jury will think that this is in fact what happened.
Your Honor, may I briefly respond?
Sure.
This is not speculation. This is a direct statement from the deceased Lou Donaldson to his daughter Cam Donaldson after he had an argument with the defendant. This is not speculation. This goes directly to how Lou Donaldson felt at the time, as it was made under, and it was an excited utterance made under an extreme stress after that fight.
So I agree. I think that the foundation for an excited utterance has been laid. I do think that there is a significant risk here that the jury could, overvalue this evidence, and there is quite a bit of prejudice. I'm going to admit it though, with a limiting instruction. So the jury's to, I'm going to inform the jury, and I can do it both in jury instructions and during trial, that they can utilize this evidence to show Lou Donaldson's state of mind, but that they are ultimately responsible. The jury is responsible for determining who was responsible for Lou Donaldson's death if they find that they do believe that he's deceased.
Your Honor.
Okay, so the objection is overruled, but I will give the limiting instruction, so I suppose sustained in part as well.
Ms. Donaldson, when your father was shaken up and you talked to him the second after that fight, immediately after that fight, what did he say to you?
He told me, if anything ever happens to me, be sure to have the police look into Karen because she will be the one responsible for my death.
Now, I want to talk to you about why we're here today. When was the last time you saw your father?
It was a Friday night around 6 p.m.
Do you remember the date?
Yes, it was August 17th of 2012.
Before that weekend, did your father mention that he was going anywhere?
No, he didn't.
And would you expect him to tell you if he was?
Yes, he would always tell me if he was traveling, even if he didn't record the flight. Not only was I his best friend, but I was also his assistant.
Why would you know this as his assistant?
Because I helped my dad do everything.
What did you do on Saturday, August 18th?
I went to bed early on Saturday night, and I was woken up pretty early on Sunday morning because the alarm at Wild Wild Life had gone off.
And what did you do when this happened?
I rushed over there because I live so close, and the police were already right behind me when I was pulling in.
And what happened when you got to Wild Wild Life?
Right when I pulled in, I noticed that the lock on the front gate had been cut, and I later found out that the back gate was also completely destroyed.
Now, Ms. Thompson, if you could turn to page 28 of the trial packet and look at what's been marked as Exhibit 004, let me know when you're there.
I'm there.
Do you recognize this?
Yes, I do.
How do you recognize this?
I've seen it before.
What is this?
It's the padlock to the front gate at Wild Wild Life.
Is this a fair and accurate representation of that padlock?
Yes, it is.
If you could turn to the next page, to page 29, and look at Exhibit 005,
Okay.
do you recognize this?
Yes, I do.
How do you recognize this?
I've seen it before.
What is this?
It's the back gate to the office at Wild Wild Life.
And is this a fair and accurate representation of the back gate to the office at Wild Wild Life?
Yes, it is.
Your Honor, plaintiff moves what has been pre-marked as Exhibits 004 and 005 into evidence as plaintiff's composite exhibit 4 and 5.
Any objection or voir dire?
Just that it lacks foundation. We don't know when these pictures were taken.
I'm going to overrule. The witness stated that this is how she observed the lock on the gate, and I believe she stated the day when she found them right around his disappearance. So overruled.
Yes, Your Honor.
Permission to share my screen with the jury, Your Honor?
Yes.
Your Honor, are you able to see my screen?
Yes.
Ms. Donaldson, if you look at Exhibit 4, a composite Exhibit 4, was this how the lock looked that night at Wild Wild Life?
Yes, it was cut straight down the middle.
And then if we turn to composite Exhibit 5, was this how the back gate looked that night at Wild Wild Life?
Yes, it was all cut up and mangled.
No. Let's go back to when you first got to Wild Wild Life. What happened when you got out of the car?
Well, I was walking towards the office building with the police officers, and that's when I saw Karen and some random person had just walked out of the office together.
What were they doing?
They were walking towards me. The random person had lock cutters in his hands, and Karen had a lockbox under her arm that looked like the same one that I keep locked away in my desk.
And what did the police do when they saw this?
Well, there wasn't much they could do. Karen told them that she was the owner of Wild Wild Life, which wasn't even true. She didn't even have a key, and she trashed the place because the back gate to the office was completely destroyed.
Did you talk to the defendant that early morning?
No, but the lockbox that she had made me really nervous.
Why'd that make you nervous?
I had a similar lockbox in my desk, and my dad kept his original will inside of that box.
Why was that lockbox in your desk?
Because my dad trusted me to protect it and to keep it safe.
Cam, did you ever get that lockbox back?
No, a few weeks later, Karen showed up with a different will.
What do you mean different?
Well, this will gave my dad's entire estate to her, everything, which was not the same will that was in the lockbox.
Would looking at that will help you testify today?
Yes, it would.
If you could turn to page 53 of the trial packet and look at what has been marked as Exhibit 0014.
Okay.
Do you recognize this?
Yes, I do.
How do you recognize this?
I've seen it before.
What is this?
It's the will that Karen had brought to me.
Is this in the same or substantially similar condition from when you last saw it?
Yes, it is.
Your Honor, plaintiff moves what has been marked as Exhibit 003 into evidence as Exhibit 3.
And for my clarification, is this what the alleged original will or the new will?
This is the new will, Your Honor, the one from June 14th, 2004.
Response, objection or voir dire to that, Mr. Nunez?
No objection, Your Honor.
Okay. 3 is admitted.
Permission to share my screen with the jury, Your Honor?
You may.
Are you able to see my screen?
Yes.
Ms. Donaldson, how is this will different from the original will?
Well, the will in the lockbox split all of my dad's assets 4 ways.
Objection, Your Honor.
Yes.
Outside the presence of jury, this witness is testifying to contents of a will that we do not have here today in violation of the best evidence rule.
Okay. Response to that, Mr. Bauer?
Yes, Your Honor. Under Federal Rule of Evidence 1004, when an original is not available, not due to any part of the plaintiff, they may talk about that, in this case, the original will, because there is no more copies of the original will. The original is not available, and not by any doing of the plaintiff.
And what's the offer of proof that, where is the original will?
Your Honor, as far as we know, the original will was contained in the lockbox at Wild Wild Life. There were no copies, and the original has not been located.
Okay. Any response to that, Mr. Nunez?
Yes, Your Honor. The plaintiff has not proved that it's more likely than not. I mean, the argument's circular. They're saying the will's lost, but that Ms. Baja had it. Additionally, they haven't proved that it's more likely than not that Ms. Baja even knew where it was. This witness just testified that it was in her safekeeping, that only she knew where it was. There was police there. There's no video footage showing that Ms. Baja was there that night, or supporting evidence from the police officers to say that Ms. Baja was in fact there that night either.
Your Honor, may I respond?
Sure.
We intend that Ms. Baja will testify that she was there. And also, under Federal Rule of Evidence 1004, the plaintiff does not need to show what happened, just that the original was lost or destroyed, and not by the plaintiff, in this case, acting in bad faith. We do not know what happened to that original will, which is why this testimony would fall under Rule 1004 of the Federal Rules of Evidence.
Okay, so I'm sorry. Pursuant to 1004, there's essentially an exception. And are you arguing A, B, C, or D?
A, Your Honor, all the originals are lost, destroyed, and not by the proponent acting in bad faith.
Okay. Mr. Nunez, do you have any indication that the original still exists, or that it's being hidden by the plaintiff in some kind of bad faith?
Your Honor, they're explaining that it. Hold 1 second to confer with co-counsel. I'm sorry.
That's fine.
Your Honor, it's the plaintiff's burden to show that.
Your Honor, may I respond?
Sure.
We laid the foundation that the original will was contained inside the lockbox that was taken from Wild Wild Life that night, and the lockbox has never been seen again, and the original will has never been seen again. Therefore, this would be protected by Rule 1004.
Okay, I'm going to overrule. You can proceed.
Ms. Donaldson, how was this new will different from the original will?
Well, the original will split all of my dad's assets 4 ways. Everything was supposed to go to me, my mom, a foundation for Wild Wild Life, and then Karen, which is completely different from the will that Karen created.
What portion of your dad's estate did Karen get under this new will?
She got everything my dad owned, including Wild Wild Life, and she also got the money from his life insurance policy.
No, let's talk more about that. What was the value of Wild Wild Life at that time?
$5 million.
And your father's life insurance policy, how much was that worth at the time?
Also $5 million.
And when did Karen get the life insurance money?
She got it around 2 years ago on the 5-year anniversary of my dad's disappearance, because she had to wait 5 years before she could have him declared legally dead, since his body was never found. And she got it the same day she had him declared legally dead.
No. Ms. Donaldson, I want to talk about how you're doing today as we are here on this Zoom screen in this Zoom trial. If you could turn to page 27 of the trial packet and look at what has been marked as Exhibit 003, take a second and just let me know when you're ready.
I'm there.
Do you recognize this?
Yes, I do.
How do you recognize this?
I've seen it before.
What is this?
It's a picture of me and my dad when I was little.
And is this a fair and accurate representation of that picture of you and your father?
Yes, it is.
Your Honor, plaintiff moves what has been marked as Exhibit 003 into evidence as Exhibit 3.
I thought 3 was in the new will.
I apologize, Your Honor. The will is 0014.
14.
Yes, Your Honor.
Okay. Objection to the photograph exhibit 13, Mr. Nunez.
Just to relevance, Your Honor.
What is the relevance of this, Mr. Bauer?
Yes, Your Honor. During this trial, it is not bifurcated, so the plaintiff must prove damages. And this goes to the damages that were suffered by Ms. Donaldson.
I think that that's a little bit far-fetched. I'm going to sustain the objection.
Your Honor, may I briefly respond?
No. Go ahead.
Cam, how has your father's disappearance changed your life?
Well, everything has been different since my dad disappeared. My world is not the same place without him. Not only did I lose my dad and my best friend, but with him out of the picture, I was fired from my job at Wild Wild Life.
Do you miss your job?
Yes, I miss Wild Wild Life. I worked there for 20 years. I worked there as a kid with my family when the business was being built. And one day I was just tossed aside at the same time that my dad went missing.
Oh, Cam, how has your relationship with your family been affected since your father's death?
I lost my family. My dad was the glue that kept us all together. And with him out of the picture, everything has just fallen apart.
No further questions.
Okay. Give me just a moment. We'll start on cross. Just a moment, please.
Bitch, I'm going to die.
Sorry, I was trying to adjust the grid view. Is anyone able to go to a grid view where it's the side by side?
Maybe if you shorten your window.
That's okay. It's not that big of a deal. It just helps for the recording purposes. Not a big deal. Ready for cross-examination, Mr. Nunez?
Yes, Your Honor. Ms. Donaldson, I just want to start by addressing an event you mentioned took place on August 19th of 2012 at Wild Wild Life. You testified that the alarm went off in the early morning, correct?
Yes.
You claim you saw Ms. Baja there.
Yes, I did.
You didn't bring this jury security footage showing Ms. Baja was there that night with a lockbox, right?
No, I didn't need to. The police also spoke with her.
So that's a no. You didn't bring any security footage.
No.
You didn't think to take a picture of Ms. Baja with your phone?
No, that wasn't my concern in that moment.
You did take a picture of a lock and a gate that day, though, correct?
Yes.
Now I want to talk to you a little bit about your role at Wild Wild Life. You used to work there, correct?
Yes, I love that job and I miss it every single day.
And you were your father's assistant, right?
Yes, I was so happy to be his assistant.
You were his assistant for 20 years, correct?
Yes, it was the best job ever.
You'd say you worked hard for those 20 years, correct?
Of course.
You were never promoted to manager, right?
No, I didn't need to since it was a family business. We all kind of ran it together.
So directing back to my question, you were never promoted to manager, right?
No, I didn't need to be.
So that's a yes, you were never promoted to manager.
Objection asked and answered.
I'm going to allow him to clarify with the witness. Overruled.
You were never promoted to manager, correct?
Yes, I was never promoted.
You were never put on the deed, correct?
No.
And you were never made co-owner, right?
No, it was a family business, so I didn't need to.
So that's a no to my question. You were never made co-owner, correct?
No, I wasn't.
As we speak, you're currently unemployed, right?
Yes.
Objection relevance.
What's the relevance of that, Mr. Nunez?
Your Honor, this witness is bringing a lawsuit against Karen Baja and her, this, I mean, it goes to the bias of the witness, which is relevant.
Your Honor, may I respond?
Sure.
This is a wrongful death lawsuit, not anything regarding unemployment.
I think it goes to her bias for potentially seeking damages, so I'm going to allow the testimony overruled.
Ms. Baja, you're currently unemployed, correct?
Yes, because I was fired from my job at Wild Wild Life by Karen.
So that's a yes, you're unemployed, right?
Yes.
You have no income, right?
No, I do not.
You thought you would inherit part of Wild Wildlife, correct?
Yes, that was always the plan until Karen came along.
I understand that's your claim, but you thought, right, that you would inherit part of it, correct?
Yes.
And that's a business worth $5 million, right?
Yes.
You did not inherit it though, right?
No, I did not.
You got nothing, correct?
Yes, I didn't get anything.
Miss Baja got everything.
Yes, she did.
Here today, you are suing Miss Baja, right?
I am.
And you want to recover $10 million, correct?
Correct.
Now I want to talk to you about your father's relationship with Miss Baja. To be clear, you never saw Karen Baja hit your father, correct?
No, but I heard her arguing with my dad.
So back to my question, you never saw her hit your father, correct?
No.
You never saw her punch him, right?
No.
You never saw her physically threaten him, right?
No. Not
You're-
physically.
And we established that you were his assistant, right?
Yes, I was.
And that you would see him a lot of days.
Most days, and I would see Karen.
And you never saw bruises on your father, correct?
No, I did not.
You didn't see your father on the day he disappeared, right?
No, I didn't.
In fact, you never saw Karen Baja on that day either, right?
Correct.
And to your knowledge, your father never called the police on Karen Baja, right?
No, but he filed a restraining order against her.
I understand that, but as far as you know, he never called the police, right?
Objection calls for speculation.
If she doesn't know, she can answer that way. Overruled.
As far as you know, he never called the police, correct?
Yes.
Now, you mentioned on direct that you helped manage your father's accounts, correct?
Yes, I did.
You never saw an invoice for a divorce attorney, correct?
No, I didn't.
No receipts for a motel room, right?
No.
Your father didn't try and move in with you, correct?
Objection assumes facts, not an evidence.
I disagree. Overruled.
Ms. Baja, he never tried to move in with you, right?
No.
And he never asked you to move in with him, correct?
Correct.
As far as you know, he stayed living with Miss Baja, right?
Yes, he did.
So let's talk about your father a little bit now. Your father was a pilot, right?
Yes, he loved to fly planes.
That's right. He liked to fly, right?
Yes.
You can't tell us how many planes he owned though, right?
No, not an exact number. I can't.
And you can't tell us where he stored those planes either, right?
Not where he stored all of them, no. But I knew where most of them were.
But you didn't know where all of them were, correct?
Correct.
You're aware that your father had his pilot license suspended, correct?
Yes, I knew that.
And you also knew that that didn't stop him from flying.
Yes, I knew he flew without a valid pilot's license, a suspended license, pardon.
That means he wasn't logging his flights when he would fly, correct?
No, not officially, but it was rare that he wouldn't tell me. Even if he didn't log the flight, he would always tell me.
So just to be clear, he wouldn't log his flights with the proper authorities when he went flying, correct?
Not always, no.
So that's a no to my question.
Yes.
Additionally, you're aware that your father, You're aware that your father's glasses were found in his van, correct?
Yes.
And you claim that this pair of glasses was his only pair, right?
Yes, he's had the same pair since I was in high school.
And he was blind as a bat without them?
Yes.
You're aware that his glasses were found in his van that was then found at an airstrip, correct?
Yes, but that airstrip was 40 miles away on the other side of town.
I understand that, but as we mentioned, you don't know where your father kept all your planes, correct? His planes, correct?
No, I didn't know where all of them were, but I knew it wasn't at that hangar.
You knew it wasn't at that hangar, but you just testified that you said you don't know where all his planes were, right?
Answered.
Your Honor, I think there was an objection.
Oh, I'm sorry. I didn't hear it. It was stopped. Was there an objection, Mr. Bauer?
Yes, Your Honor, to asked and answered. It's now the second or third time that it was asked. It was not to the it was to the previous question as to not knowing where her father kept all of his planes. It was the second time it was asked on cross.
I'm going to allow one last time. Please answer the question, Ms. Donaldson.
Sorry, Your Honor. You did not know where your father kept all his airplanes, correct?
No, I did not know where he kept all of them, but most of them, yes.
That is not my question.
I think
My
that
question-
I think that answers the question. I'm going to go ahead and not allow any further clarification on that point. You can move on, Mr. Nunez.
Yes, Your Honor. And you're aware that his glasses were found in his van at an airstrip, correct?
Yes, that was 40 miles away.
So that's a yes to my question.
Yes.
Now, your father went missing in August of 2012, right?
Yes, he did.
You hired a private investigator in July, right?
Yes, I did.
In July of 2017?
Yes.
That's a 5-year difference, correct?
Yes, it is.
In fact, you hired a private investigator after you found out that Miss Baja was inheriting everything, correct?
Yes.
Now I want to talk to you about Karen Baja a little bit. She's your stepmother, right?
Yes, she is.
You never really liked her though, correct?
No, we never had the best relationship.
She got together with your father while she was still married to your mother, right?
Yes.
Your father divorced your mother for Karen Baja.
Yes, she ruined our family.
It's safe to say, that's right, you claim she ruined your family. So it's safe to say that you hate her, right?
Yes, I believe that she killed my dad. So me hating the woman that killed my dad? Yes.
So it's safe to say that you hate her, correct?
Yes.
You actually wish she would be eaten by one of her tigers, correct?
Yes, it's my belief that she killed my dad, so I would wish worse.
So that's a yes. You did say you wish she would get eaten by one of her tigers.
Yes.
No further questions, Your Honor.
All right. Redirect, Mr. Bauer.
Yes, Your Honor, just one moment. I'm preparing my screen. Ready, Your Honor.
Go ahead.
Ms. Donaldson, why don't you like Karen Basia?
Well, I believe that Karen Basia killed my dad, and I've never really trusted her, and she came into the picture and ruined my family.
We're going to bounce around here a little bit. Where did your father keep his planes?
He kept them at multiple different airports, but I know he did not keep a plane at the airport where his car was found.
Now, today is the first time you've ever heard of anything about surveillance footage at Wild Wildlife.
Yes.
I'm just going to object to the last question. We established that she, outside the presence of jury, I'm sorry. We established that she didn't know where he kept all her planes. So to testify that she definitely knew that he didn't keep a plane at that airport is misleading to the jury.
I think you can argue that. I'm going to give a little bit of leeway here.
Yes, Your Honor.
Ms. Donaldson, today is the first time you've ever heard about surveillance footage at Wild Wildlife.
Yes.
And let's bounce around again. I'm sorry we're getting all over the place here, but why did you hire Taylor Pride in 2017?
Well, it had been 5 years, and I just found myself every single day waiting for my dad to come home. So when I finally built up the courage, I hired him to make sure that my dad wasn't in Costa Rica before Karen had him declared legally dead.
Do you remember when you hired Taylor Pride?
Yes, it was in 2017, July.
So you hired him in July of 2017, just trying to clarify.
Yes.
No. Ms. Donaldson, did you like being your father's assistant?
Yes, I love that job. I got to work with my best friend and my dad every single day. Not a lot of people can say that, and I would have loved to have that job forever. I was very happy with it.
No further questions.
Okay. Do either of our jurors request a break? Well, if not, we'll take one after the next witness. I know the initial part takes a little bit longer, so I wanted to check with Mr. Nibbs and Ms. Chandler.
I'm fine for now, Your Honor.
Great.
I'm fine, thank you.
Next witness for the plaintiff then.
The plaintiff calls Taylor Pride.
All right. Whenever you're ready, Ms. Veloz.
I believe Ms. Pride still has her mute on. I just want to make sure she's ready. Good evening. Please introduce yourself to the jury.
Good evening. My name is Taylor Pride.
Ms. Pride, what do you do for a living?
I am a private investigator and also a forensic document examiner.
Where?
I own my own private investigation firm called Pride Investigations.
How long have you had that firm?
About 4 years.
Now, as a private investigator, are you required to have any experience in law enforcement?
I am not.
Do you have experience?
I do. I was a detective for around 18 years.
What did you investigate as a detective?
As a detective, I investigated a lot of crimes ranging from murder to economic crimes. For most of my time as a detective, I was actually in the economic crime unit, and that's where I investigated forgeries.
How long were you in that unit?
I was in that unit for about 6 years.
And how did you learn to investigate forgeries?
I learned to investigate forgeries by attending a seminar put on by the American Association of Handwriting Analysts, in which they trained me to become certified in how to analyze and compare handwriting.
And when was that seminar?
That was in 2002.
What was the process like in getting certified?
So in order to get certified, we had to go through different phases of assessment. So that ranged from taking a multiple choice exam to submitting our credentials and references and going in front of an oral board.
Now, you mentioned that the seminar was in 2002. How do you stay up to date in the field of forensic document examination?
Well, I continue to get recertified every 4 years. And then I also attend annual 8-hour courses within the field, as well as stay up to date with current literature and any books written on the subject.
Ms. Pride, have you ever testified as an expert in the field of forensic document examination?
I have.
How many times?
I have testified about 15 times.
And in what type of cases?
Both civil and criminal.
And in the civil cases, what party were you testifying on behalf of?
I've testified for both the plaintiff and the defense.
Let's talk about why you're here today. How exactly did you become involved in this case?
I was hired by the plaintiff in this case, Cam Donaldson, in 2017 to investigate the whereabouts and alleged disappearance of her father, as well as to analyze his alleged last will and testament.
Now, let's talk about your investigation into Lou Donaldson's disappearance, alleged disappearance. What exactly did you look into for that part of your investigation?
So when I was investigating the disappearance, I looked at bank records, specifically Mr. Donaldson's bank account. I also looked at different pictures that were gathered of his plane and the contents of his car, including his glasses and keys, which were left within it.
Ms. Pride, would looking at the bank records help you testify today?
Yes, it would.
Take a look at Exhibit 0015 in your trial packet on page 54 and let me know when you get there.
Okay.
Do you recognize it?
I do.
How do you recognize it?
I've seen it before.
What is it?
This is Mr. Donaldson's bank account statement.
And is that bank statement signed by a records custodian from the bank?
Yes, it is.
Is it a fair and accurate representation of Mr. Donaldson's bank statement?
Yes.
Your Honor, plaintiff moves what has been previously marked as Exhibit 0015 for identification purposes only into evidence as Plaintiff's Exhibit 15.
Any objection or voir dire on that, Mr. Hobbs?
No, Your Honor.
Okay. 15, you said?
Yes.
Exhibit 15 shall be admitted.
Permission to publish to the jury, Your Honor?
You may.
Ms. Pride, what are the dates of the transactions on this bank record?
The transactions go from August 2nd of 2012 to August 17th of 2012.
And how much money was in the account on August 17th, 2012?
There was $98,727.09 in the account.
How many transactions has there been since that date?
None.
Ms. Pride, when was Lou Donaldson last seen alive?
He was last seen alive on August 17th of 2012.
How did the bank records play a role in your investigation?
Well, when looking at the bank records,
Your Honor.
Yes.
There's lack of foundation for an expert conclusion. Further, there hasn't been no official tender to Ms. Pride's area of expertise and the scope of their expertise.
I tend to agree. I think there's foundation for potential expert testimony. Did you wish to tender Taylor Pride as an expert in a specific area, Ms. Willis?
Yes, Your Honor. The plaintiff seeks to tender Ms. Pride as an expert in forensic document examination as well as a private investigator, Your Honor.
Any objection to that tender, Mr. Hobbs?
To the latter half, Your Honor, as a private investigator, that is vague and relaxed specificity as required under 702.
I tend to agree with that as well. I agree the forensic document examination. I think that is specific as necessary. Is there an area in private investigation? And just so you know, Ms. Willows, if her testimony regarding investigator work is general enough, it may not require expert testimony. Is there something specific you think that would delve into the area of necessary expert testimony?
I don't believe so, Your Honor. I think that Ms. Pride will testify as to, surrounding circumstances being something that she looks into as a private investigator, since she's not confined, to a police investigation. I don't believe there's anything specific as a private investigator that she will be getting into, but I won't tender her as an expert in private investigation. She does have years of experience as a detective and working in murders as well as, in economic crime. I believe the witness will be able to talk about her experience as well as rely on her training in talking about Lou Donaldson's disappearance and her investigation into that alleged disappearance.
Okay, let's go just outside the presence of the jury for a moment. Yep. I definitely think the forensic document examination would require expert testimony. There's been no objection to that, so that's clear. When it comes to police investigation and work, as I think probably the parties are aware, there's definitely a trend nationwide and also in individual states towards certain areas of police or investigative testimony requiring specific expert testimony instead. For example, like, roadside sobriety maneuvers, forensic interviews of children. There's, some specific areas. Right now, I don't think any testimony like that has been elicited. So I'm going to allow her to testify as a lay witness as it relates to the work she did as an investigator in this case. But Mr. Hobbs, if you think she's being asked to testify as to something about an expert, I'm not, precluding you from objecting to that. And Ms. Veloz, if you get to a point where you think expert testimony is necessary, I'm not saying you can't, lay additional foundation or make that request. And so, does that make sense?
Yes, and if I may just clarify on one thing, Your Honor. It was my understanding that in this jurisdiction, we didn't have to tender the witness as it goes to improper bias. It would be best for the jury to evaluate the expert's opinion and investigation. However, I will tender the witness if that's your ruling, Your Honor. It was my understanding that we didn't need to in this specific jurisdiction. And I apologize, it's my first time trying a case in this jurisdiction.
No apology necessary. I can vary courtroom by courtroom. I prefer to have the specific tender. So no apology necessary at all.
Understood.
Any other clarification?
No, Your Honor.
Mr. Hobbs?
No, Your Honor.
Okay, great. We'll go back to in front of the jury. Thank you.
Ms. Pride, you mentioned that you looked at a picture of Lou Donaldson's plane. Would looking at that picture help you testify today?
Yes, it would.
Take a look at Exhibit 001 in your trial packet and let me know when you get there. It's on page 20.
Okay.
Do you recognize it?
Your Honor, I'm going to object.
Okay, what's the basis?
Outside the presence of the jury, I believe Ms. Pride is about to testify how she examined one of Lou Donaldson's planes. This was nowhere in her expert report and thus violates the notice requirement of the Federal Rules of Civil Procedure 26.
Okay, response to that, Ms. Veloz?
Your Honor, in the expert's statement, the experts say that she looked into Lou Donaldson's plane as a private investigator. She's not limited to the confines of a police investigation. She'll look into the surrounding circumstances. She'll look into the type of vehicle plane that was used. This is one of the type of planes that Lou Donaldson owned, and that's why I'm eliciting this testimony, Your Honor.
And I'm sorry, I'm going to need just a little clarification. Mr. Hobbs, your objection is that this information was not provided to the defense?
Yes, Your Honor. Nowhere in the expert report does she discuss how she evaluated one or a type or the same model of planes. To bring it out now during trial would violate the notice requirement of Rule 26.
Your Honor, if I may respond?
Yeah.
The expert's statement does state that she looked into the type of plane that Lou Donaldson owned. And I will give you the page number. It's on page 4 of Ms. Pride's statement. In the second paragraph, the 8th line from the second to last paragraph, if I may offer the statement, Your Honor.
And are you moving to admit an exhibit right now with this? Because I thought that's where the question line was going. Am I correct in that or no?
Yes, Your Honor. It's a picture of the type of plane that Lou Donaldson owned. Ms. Pride looked into this plane. Ms. Pride looked into the distance between Statesville and Costa Rica and the type of how many refueling that specific type of plane would need. That's the reason that I'm bringing it in.
Okay, so I'm going to overrule at this point. If it starts to get beyond that, Mr. Hobbs, you can re-raise your objection or cross-examine on this. And obviously there'll need to be foundation laid for this particular exhibit. But so far, I think we're getting a little ahead of ourselves because I'm not really sure where this is going quite yet. So I'm going to allow Ms. Veloz a chance to lay some foundation.
Yes, Your Honor.
Ms. Pride, do you recognize this?
I do.
How do you recognize it?
I've seen it before.
And what is it?
This is a photograph of one of the planes that Mr. Donaldson owned.
And is it a fair and accurate depiction of one of the planes that Mr. Donaldson owned?
Yes, it is.
Your Honor, plaintiff moves what has been previously marked as Exhibit 001 for identification purposes only into evidence as Plaintiff's Exhibit 1.
Do you wish to voir dire or object to this, Mr. Hobbs?
Yes, Your Honor, just a brief voir dire.
Yes, go right ahead.
To clarify, Ms. Pride, you're saying that the proffered picture is an exact picture of a plane owned by Mr. Donaldson?
Mr. Donaldson owned the type of plane that's exhibited in that photograph.
Nowhere in your report do you detail how you examined this type of plane, do you?
I didn't look at the physical plane. I just examined how many refuelings that type of plane would take to get from where Mr. Donaldson was to Costa Rica.
Right, so that's a no to my question.
I did not physically examine the plane, no.
Nowhere in your report do you articulate how the specifics of how many refueling stops are withdrawn. Nowhere in your report do you articulate how you examined his plane and how you came to the determination that needed 3 to 4 refueling stops.
I don't think I articulated the specifics of how I got to that conclusion, no.
Nowhere in your report do you discuss how you confirmed that this is actually a model plane owned by Lou Donaldson?
No.
No further questions for voir dire, Your Honor. I do move at this moment that this witness has not laid the proper foundation to discuss and testify about this model of plane. We don't even know if this was the type of plane owned by Lou Donaldson outside the statement and report of Taylor Pratt.
Response to that, Ms. Veloz?
Your Honor, the witness is a private investigator, and in doing so, she looked into Lou Donaldson's life. She's claimed that this is one of the type of planes that Lou Donaldson owned. Ms. Pride spoke, through family and friends. She got information through Cam Donaldson herself. Cam Donaldson has vast knowledge about Mr. Donaldson's. Taylor Pride spoke to Cam Donaldson. This is where she got her information from. She looked at the type of plane that Lou Donaldson owned. Although she didn't physically look at the plane, that doesn't mean that Ms. Pride couldn't find this information over the internet. And that's why this evidence should be admissible. Ms. Pride was hired to look into Lou Donaldson's alleged disappearance. And in doing so, she had to look at the claims that the defendant made, which was that Lou Donaldson went to Costa Rica. That's why she examined this specific type of plane.
I'm going to sustain the objection. The witness testified that this wasn't Mr. Donaldson's exact plane. I feel the foundation is a little lacking for how she has this information. I'm worried it's going to confuse the jury. I'm going to sustain the objection pursuant to Rule 43. I'm not going to prohibit you from asking, some additional questions about the effort she took into his airplane should you want to, but I'm not going to admit Exhibit 1. And again, I don't think additional foundation, given the fact that it's not its plane, is going to change that. So objection sustained.
Your Honor, if I may just clarify, I may ask how the plane played a role in the investigation. I just may not admit the picture of the evidence.
If you want to ask how she did some investigation on a plane or how she thought it was his, you can, though I think some of that may be subject to hearsay objections or some other objections. And so it's your decision if you want to continue down that path. But I'm concerned there's likely going to be objections for some of these, but again, you would know that better than I. And I also need to go off the record for just a moment. I have 2 people who have been requesting, and again, we're off the record for just a moment, to enter the room. I don't know, I'm not familiar with who they are. It's Larissa, I believe, Kern, and maybe Diana Goldenberg. Does anyone know these individuals, and are they people who should be present in our room?
Yes, Larissa Kern's playing Karen Bashia today.
Okay, and does anyone know Diana Goldenberg?
No, Your Honor.
No one? Okay. I'm going to go ahead and admit Ms. Kern.
Honor, think it may be some confusion with the Western bracket trying to join a courtroom, and they may be trying to join our rounds rooms on accident for the other person.
Okay. I'm sorry to interrupt your examination, Ms. Veloz. They've been waiting for a minute, and I just I had forgotten about them, so I didn't want to be rude. And I think she's left, so I think it's fine. So apologies for the interruption. Please continue with your cross-examination, Ms. Veloz.
For the record, it's the direct examination, Your Honor.
Oh, I'm sorry. Direct examination. My apologies.
No worries. Ms. Pride, you mentioned, let's go back a bit. How did the bank records play a role in your investigation?
Well, when I was looking at
Again,
the,
your objection.
And what's the basis?
Again, offering improper expert opinion. We anticipate that that Ms. Pride would testify how the bank records played a role and affected her conclusions about the private investigative end of her report and her investigation. She's not been tendered as an expert in the field and thus cannot give opinions in this regard.
I'm going to overrule. I think that how the bank records may have impacted her activity, including investigation, is valid lay testimony. So overruled.
Ms. Pride, how did the bank records play a role in your investigation?
when I was looking at the bank records, I was trying to determine whether there were any indicators that Mr. Donaldson may be in Costa Rica, as Ms. Bossia claimed. But when I looked at his account, there was nothing indicating that he had made any transactions in Costa Rica. And I also looked at his plane, which corroborated that.
Now, how far is Costa Rica from Statesville?
It's 2,200 miles away.
And did you yourself look into Costa Rica?
I never myself went to Costa Rica, but I did send an employee to Costa Rica physically, and that employee did not find any indicators of Mr. Donaldson in the country.
Now, you mentioned that you looked at photographs of Lou Donaldson's glasses. Would looking at the glasses help you testify today?
Yes, it would.
Take a look at Exhibit 0013 in your trial packet and let me know when you get there.
Okay.
Do you recognize it?
I do.
How do you recognize it?
I've seen it before.
What is it?
This is a photograph of Mr. Donaldson's keys and glasses in the interior of his vehicle.
Now, is it a fair and accurate depiction of Lou Donaldson's glasses?
Yes.
Your Honor, plaintiff moves what has been previously marked as Exhibit 0013 for identification purposes only into evidence as Plaintiff's Exhibit 13.
Any objection or voir dire?
No, Your Honor.
Okay. Exhibit 13 shall be admitted.
Permission to publish to the jury, Your Honor.
Okay.
Ms. Pride, how did the glasses and keys play a role in your investigation?
Your Honor, I will have to object to this. Again, this is a lay witness testifying about conclusions outside of their tendered field of expertise.
For the same reasons stated before, overruled.
Ms. Pride, how did the glasses and keys play a role in your investigation?
Well, throughout the course of my investigation, I learned that Mr. Donaldson wears his glasses, so I found that it would be quite difficult for him to fly a plane without these two items.
Let's talk about your investigation into the alleged will. What exactly did you look into in investigating the alleged will?
So when I was examining the will, I was looking at the will itself, the language contained in the will, the signatures present on the will of both the witnesses and Mr. Donaldson, as well as the surrounding circumstances of when and where the will was produced.
How many wills have you reviewed in the past?
Countless wills throughout my career.
Would looking at the alleged will help you testify today?
Yes, it would.
Your Honor, permission to republish Plaintiff's 14?
You may.
Ms. Pride, what are we looking at here?
We are looking at Mr. Donaldson's alleged last will and testament.
And what are the components of this will? Feel free to annotate on the screen if you feel comfortable doing so.
So the first box that I'm drawing up top shows the language of the will that I'm examining, the content of the will itself. Below that, we see Mr. Donaldson's alleged signature on the will. And then below that, we see both witnesses and their signatures. The first one being from Samantha Lane and the second one being from Karen Basia.
Ms. Pride, what is the purpose of having a witness on a will?
The purpose of having a witness is to corroborate the fact that the deceased person did in fact sign that will.
Were you able to confirm that here?
I was not.
Why not?
Well, I reached out to Samantha Lane throughout my investigation, and she indicated to me that Miss Basia.
Objection, Your Honor.
Basis?
This question calls for hearsay.
Response to the hearsay objection, Ms. Lowe's?
Your Honor, the witness is going to testify as to a statement made by the defendant under Federal Rule of Evidence 803 D2A. It's a party opponent admission, Your Honor. If I may proffer the statement.
Yeah, so you're saying it's and outside the presence of the jury for the proffer, it's a statement by Miss Basia?
Yes, Your Honor. It's a statement that Miss Basia said to Miss Samantha Lane.
Okay, and what about the hearsay from Miss Lane's statement?
Your Honor, under Federal Rule of Evidence 703, the expert may disclose otherwise inadmissible evidence if the probative value in evaluating the expert's testimony substantially outweighs the risk of unfair prejudice. Ms. Pride is a forensic document examiner, and as a forensic document examiner, she reasonably relies on the testimony of the witnesses, talking to witnesses, and for that matter, we seek to admit the evidence, the testimony that was given, the statement that was made by Samantha Lane.
Response to the 703, Mr. Hobbs?
One moment, Your Honor, to confer with co-counsel.
Sure.
Yes, Your Honor. This fails the standard under 7.3 as it is substantially more prejudicial than it is probative. Having this statement against Ms. Basia without the witness here today to test the credibility and reliability of the declarant would do is inflame the passions of the jury against Ms. Basia.
Your Honor, may I respond? The fact that Samantha Lane said that she didn't witness Lou Donaldson sign the will and that she was threatened by the defendant will not cause the jury to make an improper decision based off of that testimony. It should be admitted under 703, and Your Honor, and if it is admitted under 703, it won't come in for the truth of the matter asserted, but rather to help the jury evaluate everything that Ms. Pride investigated and ultimately her opinion. It would be left to the jury to make that conclusion in the end, whether or not it was prejudicial or not, Your Honor.
Well, I'm sure there's some prejudicial effect since Ms. Lane's not here to be subject to cross-examination. I don't disagree with Mr. Hobbs. However, I think that the probative value is extraordinarily high in this situation. And so I'm going to overrule the objection and admit this evidence.
Ms. Pride, what did you find out from Samantha Lane?
Samantha Lane relayed to me that Miss Basia threatened to feed her to the cats if she didn't cooperate in signing the will, and that she actually had never witnessed Mr. Donaldson sign it.
Now, you mentioned earlier that you analyzed the will itself. How did that play a role in your investigation?
Well, when I was analyzing the will itself, I found particular language within the will to be suspicious. Specifically, the disappear language in the will I found particularly a red flag.
Why would you say it was a red flag?
Because never in my years as a document examiner have I ever seen a will contain the language "if I disappear."
Let's talk about Mr. Donaldson's signatures, but before we get there, what is your process generally in investigating forgeries?
When I am investigating forgeries, I'm going through a 3-step process.
What's step number 1?
The first step is that I'm going to gather known signatures or writing of the person whose handwriting or signature I'm analyzing.
What type of samples do you typically look for?
So the samples that I'm gathering are things like journal entries, things that the person may have written down in a notebook through the course of ordinary daily activities. Something like a grocery list would suffice as well.
And what's step number 2?
So the second step is to identify the characteristics of that person's handwriting within those known samples. So the characteristics I'm looking for are anything that stands out. So capitalization, the stroke, the legibility of that person's handwriting, among other things.
And what's step number 3?
So the third step is to take those known samples and the characteristics that I've determined and compare those to the alleged forgery.
What do you typically look for in comparing the sample signatures to the alleged forgery?
So I'm looking for any hesitation that the person may have had when analyzing the forgery. I'm also looking at any unnatural signs in that person's writing. So anything that stands out as distinctly different from the samples that I've collected, and also any retouching that the person may have done in an attempt to make the forgery look more like the authentic samples.
How do you know if there has been any hesitation in the writing?
So as an examiner, we know when there's hesitation if there are quivering lines within the piece of writing.
Now, I want to talk to you about your step number 2, your process in this case. What samples did you collect?
So the samples that I collected in this case was a signature from Mr. Donaldson's driver's license, a signature that he had on a restraining order, as well as a note that was written by him.
Now, I want to talk to you about step number 2, but before we get there, would looking at the signatures help you testify today?
Yes, it would.
Take a look at Exhibit 007 in your trial packet, page 40, and let me know when you get there.
Okay.
Do you recognize it?
I do.
How do you recognize it?
I've seen it before.
What is it?
These are signatures of Lou Donaldson that were collected.
Your Honor, plaintiff moves what has been previously marked as Exhibit 007 for identification purposes only into evidence as Plaintiff's Exhibit 7. Also, Your Honor, prior to trial, the plaintiffs met with opposing counsel and we agreed to redact some of the information on the signature comparison. So when I pull it up, that information will not be there.
Okay. Any objection or voir dire with that explanation, Mr. Hobbs?
No, Your Honor.
Okay. The redacted version of Exhibit 7 shall be admitted.
Your Honor, permission to republish Exhibit 7 as well as Exhibit 16.
You may.
Thank you. Ms. Pride, please indicate on the screen exactly which signatures you collected.
So the first signature that I collected is the second one here. So that's going to be the signature from Mr. Donaldson's driver's license. And then the one below that is also the alleged signature from the will that I looked at. And then on the right, we see the signature from the restraining order.
Ms. Pride, what did you find in analyzing the sample signatures?
So when I analyzed the signatures, the sample signatures, I noted what distinct characteristics Mr. Donaldson exhibits. So the characteristics that I was looking for were in individual letters as well as the overall signature. So I'll start with the overall signature. When looking at the known signatures, Mr. Donaldson has what I would call a kind of single stroke style. So he doesn't lift the pen. He tends to just go through letters without doing so. And then within individual letters, there are also distinct characteristics, such as you can see the embellishment on the N at the end of his name, as well as if we look at the first L in Lou, we see that there's a smaller loop at the top and then a bigger loop at the bottom. Another thing that stood out about Mr. Donaldson's signature was the O in Donaldson. So the O is what we would call a lazy letter in my field, which means that the person doesn't make it prominent in their signature. They're not making it stand out. So that was something I also looked at.
Now, just to clarify, when you talk about the O in Donaldson, you mean the second O in Donaldson, correct? Now, Ms. Pride, what did you find in comparing the sample signatures to the signature on the will?
So when I compared the sample signatures, I noticed very considerable differences, not only in the overall signature, but also individual letters. So in terms of the overall signature, I can see that the person is quivering. So the lines aren't fluid, which indicates to me that either the person is nervous and or copying, as well as the person is lifting the pen. So particularly if we look at the D in the alleged signature, there are clearly two distinct places where the person lifted the pen in order to make that character, which is not present in the known signatures of Lou Donaldson. And then if we look at the second O in Donaldson, which was the lazy letter that I talked about, it actually stands out in this alleged signature, which is not characteristic of Mr. Donaldson's known signature.
Ms. Pride, did you reach a conclusion in this case?
I did.
And was that conclusion within a reasonable degree of professional certainty?
It was.
What is your conclusion?
My conclusion is that the signature on Mr. Donaldson's last will and testament was forged.
Thank you, Ms. Pride. No further questions.
All right. Cross-examination, Mr. Hobbs?
Yes, Your Honor, one moment.
Good thing.
Permission to proceed?
You may.
Good afternoon, Ms. Pride.
Good afternoon.
Ms. Pride, you're a private investigator, correct?
I am.
As you testified, you were hired by the plaintiff, Cam Donaldson, right?
I was.
You were hired to investigate Lou Donaldson's disappearance.
Correct.
You weren't hired back in 2012 when Lou first disappeared, right?
I was hired in 2017.
That's right. You were hired in 2017, just a month before Karen Baja could collect the life insurance policy, right?
Correct.
The plaintiff is also paying you to testify here today, right?
Yes, like any expert, I get paid.
So that's a yes.
Correct.
Now, in conducting your investigation, you said you received some information from Cam, the plaintiff.
Yes.
Specifically, the plaintiff told you about Ms. Baja's alleged break-in into the Wildlife Emporium, right?
I was told that.
You weren't there to witness this alleged break-in, right?
No, I was not.
You didn't bring us security footage showing this alleged break-in?
No.
You didn't follow up with the sheriff's office to confirm that this alleged break-in actually happened?
No, I didn't.
You didn't follow up with Karen to see her side of the story?
No.
You just took Cam's word for it?
I formed a relationship with Cam and I listened to what she had to say.
So that's a yes. You just took his word for it.
I took what Cam had to say into consideration in my investigation, yes.
Now, Ms. Pratt, I want to talk about your handwriting analysis. You received a note from from the plaintiff, right?
I'm not sure what you're referring to.
I'll rephrase. The plaintiff gave you a note his father had written him, correct?
Oh, yes.
That note was made in May 2012,
Correct.
just a month before the executed will was made, correct?
Yes.
You can't tell us the writing characteristics from that note, right?
I gathered characteristics from that note.
But you can't tell us what those characteristics are, right?
I gathered characteristics and took that into consideration in my analysis.
So you're saying that your testimony here today is that you analyze the writing characteristics of the note given by Lou Donaldson.
So throughout the course of my investigation, when I was doing a handwriting analysis, I did examine a note that was written by Mr. Donaldson.
But you did not compare the handwriting from that note to the one on the execute will, correct?
I did take into those characteristics in that note and determined that they were distinctly different from the characteristics present on the will.
So it's your testimony here today that you analyzed the handwriting in that note and compared it to the executed will, correct?
I took into consideration those characteristics, yes.
So that's a yes.
Yes.
One moment, Your Honor. Ms. Pride, you made a report for your investigation, correct?
Correct.
You knew that this report would be used in today's trial.
Correct.
So you want to be thorough with this report?
What?
You want to be thorough with this report?
Yes, as thorough as I could.
You want to be accurate with this report?
Yes.
You want to lay out every step you took in analyzing the handwriting from the executed will?
Correct.
Referring court and counsel to page 18 of the case record, the first full paragraph on the third page of Taylor Pride's report. Ms. Pride, do you have this in front of you?
I can pull it up. Give me one moment. Okay.
Ms. Pride, the first two full paragraphs in this report is where you discuss what handwriting characteristics you received from the samples, correct?
Correct.
Nowhere in these two paragraphs do you discuss what handwriting characteristics you got from the note from Lou Donaldson, right?
I don't explicitly discuss the exact characteristics found in the note, no.
So that's a no to my question.
Do I specifically mention the note in that? No.
That's a no to my question, correct?
Objection.
I did not mention the note.
And nowhere in these two paragraphs do you discuss how you compared the handwriting from Lou Donaldson's note to the handwriting on the executed will, right?
I don't discuss the specifics, no.
You don't discuss it at all, do you?
I don't mention the note in those two paragraphs you're mentioning now.
One moment, Your Honor. Ms. Pride, you were hired to investigate. Ms. Pride, you investigated Lou Donaldson's disappearance for 3 years, correct?
Correct.
You knew that he worked at the Wild Wildlife Emporium.
Yes, he did.
He spent a lot of time there.
Yes, he owned it.
You didn't bring us any statements from the Emporium's employees pertaining to his possible whereabouts.
Throughout my investigation, there is nothing indicating his whereabouts.
So that's a no to my question.
There are no indicators of his whereabouts, so I would not have brought that
I
information.
understand that you're claiming that there's no indicators. My question is, you didn't bring us any statements, correct?
Statements? No.
You didn't. In fact, you can't even tell us how you investigated the Emporium's grounds during your investigation, correct?
No.
Now, you mentioned how you addressed the Costa Rica theory. You claim to have sent an employee to Costa Rica, right?
I sent an employee to Costa Rica.
And you claim that they couldn't find anything.
Correct. They found no indication that Mr. Donaldson was in Costa Rica.
To be clear, you sent one person to search an entire country.
I sent one of my private investigators to look in Costa Rica.
That's a yes to my question.
Correct.
You can't tell us how long this employee was in Costa Rica looking for Lou, right?
The specific amount of time, no.
You can't tell us how they conducted their investigation.
Well, they're my employees, so they would conduct the investigation within our normal work practices.
Right, but you can't tell us the specifics of how they conducted their investigation for Lou Donaldson.
I can't give you a blow-by-blow of what exactly went on when they were in Costa Rica.
You can't tell us if they spoke to any airport personnel in Costa Rica?
No.
You didn't bring us any reports saying that they searched the refueling stations between Statesville and Costa Rica, correct?
No.
As far as you're concerned, this employee of yours is not testifying for your client today, right?
No, I am.
Right, but this employee of yours is not testifying.
No.
And you don't have you didn't bring us a detailed report of their investigation in Costa Rica, correct?
No. I just took the information that they relayed to me as my employee.
So that's a no. You didn't bring us a detailed report of their investigation in Costa Rica.
Their investigation, no.
You didn't bring us a sworn statement from them saying that this investigation actually happened.
No.
Sitting here today, you can't even tell us this employee's name, can you?
No, I'm not going to provide the name.
Even though so to be clear, under oath, you are not going to tell us this employee's name.
No.
You didn't think any of this information would be helpful in today's case?
No, as I was the one hired to investigate the disappearance. And so, what my opinions were and the conversations that I had are what is important to me.
So that's a no to my question.
That would be a no.
Ms. Pride, you're aware that Lou Donaldson was a pilot,
Yes, he was.
and you're aware that his van was found at an airstrip, right?
Can you repeat that? Sorry.
You're aware that his van was found at an airstrip, right?
Yes.
You didn't bring us any statements from those airstrip employees, correct?
I did not get in contact with.
Objection, Your Honor. I'm going to object to relevance as to the statements of people at the airstrip. It's not relevant in this case.
Response to that, Mr. Hobbs?
Your Honor, under Reds, Ms. Pride went extensively into how she investigated Lou Donaldson's disappearance. The plaintiff has the burden today, and the jury has the right to know what they did and did not bring from that investigation.
I agree. Overruled. You can ask your question.
Ms. Pride, you didn't bring us any statements from those airstrip employees, correct?
No, I did not have contact with them.
That's right. You never reached out to them.
No, I didn't have that information.
You didn't look for that information, did you?
I never got in contact with the people at the airstrip, no.
So that's a no to my question.
Right.
You didn't bring us any security cam footage from that same airstrip, did you?
I'm not even sure if there were cameras there.
You're not sure because you didn't even search that airstrip during your 3-year investigation, correct?
Objection argumentative.
I apologize. Outside the presence of the jury, what was your question, Mr. Hobbs?
You don't know because you didn't even investigate that airstrip during your 3-year investigation.
I feel like we're getting into territory of asked and answered. I'll overrule, but I'm going to ask you to move on shortly, Mr. Hobbs.
Yes, Your Honor. Ms. Pratt, let's talk more about your investigation. Sitting here today, you can't tell us how many planes Lou had, right?
No, I don't think anyone has that information.
No one, including yourself, who was a private investigator for his disappearance.
Correct.
You can't tell us if any of his planes are missing.
Correct.
You didn't bring us traffic cam footage showing Lou's whereabouts the days leading up to his disappearance.
No, I didn't. And I was also not really involved in the case at that point.
You can't tell us how you tried to trace Lou's steps the days leading up to his disappearance.
No, again, I wasn't involved in the case at that point.
I understand that's what you're claiming, Ms. Pratt, but I'm asking about your investigation. During your investigation, you can't tell us how during your investigation, you tried to trace Lou's steps the days leading up to his disappearance.
Objection asked and answered.
Your Honor, she has not given an answer yet.
Overruled. She can answer.
Leading up to his disappearance, I wouldn't have been tracking his whereabouts, so no.
I'm so sorry, Your Honor. The fire alarm's going off in my apartment building right now. Can I have 1 second to turn it off?
That's fine. Take your time.
I believe it's been resolved. So sorry about that.
No apology necessary. These things happen right now, honestly.
I'm sorry, I believe we were in the middle of opposing counsel's response.
I think the witness answered that she was not involved with the investigation at that time. And I think she's answered the question. If you want to go and continue, Mr. Hobbs.
Yes, Your Honor. Ms. Pride, you can't tell us. Ms. Pride, you didn't bring us a statement from Lou's friends about his possible whereabouts, did you?
No.
You didn't bring us a statement from his neighbors about his possible whereabouts.
No, he disappeared. They don't know where he is. No one does.
But you never asked them, correct?
I didn't have contact with specific friends, no.
So that's a no to my question.
Correct.
You didn't get a statement from his ex-wife?
I did not.
You didn't contact Lou's family besides Cam about his possible whereabouts?
No.
You don't even know where Lou's family is located besides Cam, do you?
No, and they weren't pertinent to my investigation as they wouldn't have been around at the time.
But you don't know that because you never reached out and asked them.
Objection asked and answered.
I'm sorry, I didn't quite hear that.
Objection asked and answered.
I think we're starting to get into that territory. I'll let you ask it one final time, Mr. Hobbs.
That's because you never reached out to Lou's family besides Cam. Isn't that right?
I didn't feel the need to, no.
Sitting here today, you don't even know if Lou has other family members whom he could be staying with right now.
There's no indication of that.
So that's a no to my question.
That's a no.
You had 3 years to get this information, correct?
I've been investigating for 3 years.
So that's a yes to my question. You had 3 years to get all this information.
3 years to gather information, yes.
This information could have affected your investigation, correct?
Again, there are no indicators that would have led me to believe that. So if there were, yes, but there weren't.
So that's a yes to my question.
Yes.
No further questions.
Right. Any redirect, Ms. Veloz?
Yes, Your Honor. Ms. Pride, how did you obtain the pictures of the glasses and keys?
So those were taken by police officers in the police department.
Why didn't you go to the airstrip?
Because I wasn't involved in the case until 2017, and I didn't think at that point it would be pertinent to the investigation, as who knows how the airstrip may have changed during that time.
Thank you, Ms. Pride. No further questions.
All right, thank you. Are there any additional witnesses for the plaintiff?
Yes, Your Honor. The plaintiff has 2 unavailable witnesses.
Okay.
First, the plaintiff would like to read in the deposition testimony from Carl Bannister, dated October 30th, 2019. We would like to read in portions of this testimony.
Okay. Is there any objection from the defense?
Your Honor, can opposing counsel refer us to the specific page and line number, or at least area of the page for the deposition?
Yes, Your Honor. Maybe we go sidebar.
Sure.
During the reading, we intended to point out the page number, as the pages do not contain line numbers. For this deposition, we were just going to refer to the page number, sort of where it is on the document, and read it in that way. I was going to, my co-counsel, I was going to ask the questions, and my co-counsel Esther Veloz was going to read the answers to expedite the process.
I don't have any problem with that procedure. In defense, if there's something, you know, that you need to object to, or that's objectionable, you can object. And I'll also give defense the opportunity as kind of a cross-examination to read in portions that they want as well. And so that's fine with me. You can go ahead.
Reading the October 30th, 2019 deposition of Carl Bannister, on page 2 of the deposition, which would be page 34 of the trial packet. Did you drive her back home?
I first took a look at her car and it would not start. So I made sure it was safe by the side of the road and then took her home. We got to her house around 3:45 a.m., definitely before 4 a.m.
Further down on page 34. Did you go into the home at all that night?
No, I was on duty and had to get back to work. I dropped her off, wished her luck with the Cubs, and headed off.
Continuing on page 35. Did you go right back to work?
I may have stopped for coffee and a snack. It was a while ago. I don't really remember.
Are you aware that the Pioneer County Sheriff's Office keeps tracking records for all vehicles?
Sure. It's a good way to know where each deputy is located in the jurisdiction during a shift.
Your
Are you-
Honor, we just object to the reading. There was some emphasis in that characterization of the testimony.
I think the jury understands that this is counsel and not the witness itself. And if need be, you can move to admit the transcript as well.
Are you also aware that there is no record of your patrol vehicle moving from 3:20 a.m. until nearly 6:30 a.m. as it was showing it was near the grocery store, close to Miss Basia's home during that time?
Yeah, I looked back at it in preparation for this deposition, and the records show that my transponder, the device that gives the location of the patrol car, was malfunctioning, cutting in and out. The issue was noted in a maintenance log, and it was replaced the next day.
Turning to page 36, the final question in the deposition. You said you went back to your patrol duties after you dropped off your sister. Did you answer any calls the rest of the night?
No, I looked back on it and it was a quiet night. I just did my regular patrols and did not have any incidents. So there were no reports for the rest of the night.
That can ends the reading of the deposition, Your Honor. At this time, the plaintiff seeks to move in the vehicle maintenance report of the Pioneer County Sheriff's Office submitted by Carl Bannister on August 18th, 2012. And that has been pre-marked as exhibit, excuse me, one moment. I believe 0017 has been pre-marked as exhibit 0017 into evidence as exhibit 17.
Sorry, is that 7 or 17?
17, Your Honor.
Objection or to exhibit 17.
One moment, Your Honor. Yes, Your Honor, we renew our motion, our same objection from motions in limine, this is still 2 layers of hearsay with the statements of Carl Bannister being without exception.
Yeah, I tend to agree. I'm going to sustain the objection and not admit the maintenance form. I just don't think there's sufficient foundation at this point for it. So I'm going to sustain that objection.
Understood. Plaintiff,
I'm sorry.
I apologize, Your Honor.
Does the defense have any cross-examination for this witness in terms of wanting to include any other testimony from Mr. Bannister's sworn statement?
No, Your Honor.
Okay. And I believe the plaintiff has one final witness.
Yes, Your Honor. Plaintiff calls Exotic Bob in the form of a video. Permission to share my screen?
Yes, and I think this was litigated in motions, and I admitted it over the defense objection, which I'm still questioning myself on, Mr. Nunez, but here we are. So
we'll renew our objection.
for the record, but it is admitted. Please feel free to publish that, Mr. Bauer.
Yes, Your Honor. One moment. I am pulling the video up right now.
And for the record, what exhibit number will this be? Quiz. I'm teasing.
A moment to confer with opposing.
It's fine.
It'll be 17, Your Honor.
Your Honor, are you able to see my screen?
Yes, I am. Thank you.
I am sharing my computer audio, so everyone should be able to hear. If at any time you can't, please let me know.
Hey there, cat sister, where you put your mister? Feed him to the lion's den. Hey there, cat sister, where you put your mister? Feed him to the lion's den, den, den. Hey there, I'm Exotic Bob. You probably recognize me as the owner of the world-famous leopard camp, I See Spots. I want to thank you for your patronage over all these years. I'm currently a guest of the federal maximum security hotel system. Compliments of one Karen Baja, and that's who I'm here to talk to you about today. You see, it was 2 years, 2 weeks, and 2 days to the day that her husband was last seen alive. She and I was working on a highly illegal deal. We was illegally importing leopards and lions. Leopards was for her, leopards was for me, lions was for her. Now, we'd never worked together before, and we'd never worked together since. But due to the severe illegality of the deal, we thought it best to be worked together, so we did. And at the end of that meeting, Karen Baja walked out of my office. She stopped suddenly, turned around, and she came marching back to my desk, and she leaned over and she looked me right in the eye and she said, "Exotic Bob," that's me, Exotic Bob. She said, "Exotic Bob, I swear if you double-cross me on this deal, I will do to you exactly as I did to my husband." She said, "There won't be no disappearance, no mythical flight to Costa Rica." She goes, "Your last supper will be you. I'll feed you to my kiddies just like I did him." And then she turned around and she walked out of my office. That's all I've got to say about that. Hey there, evil woman, where you think you're going? We all know where you've been. Hey there, evil woman, where you think you're going? We all know where you've been.
Any further witnesses for the plaintiff?
No, Your Honor. Plaintiff rests.
Okay. I'm sure defense probably has a motion they want to make, but I'm going to go ahead and take a brief recess, and then we can, if there are any motions, we can make them when we return. So it's 6:31 my time. Why don't we go ahead and take, let's try to keep it at 9 minutes if possible, so that we can start back up at 6:40. Will that be enough time for people? Does that feel okay?
Yes, Your Honor. Can we also get a time check?
Yes, and I think you have people doing time checks, so I think witnesses are correct.
I believe so, yes.
Okay. I was not, so I'm fairly certain it's a witness. So we'll have them work on that, and we can do that when we get back at 6:40. Thank you. Taylor Dobbins, someone to admit? Do we know? Does that name ring a bell for anyone?
No, Your Honor.
Yes, I believe that's our expert.
Okay. Oh, I think she left.
I will contact her.
Okay. Oh wait, back. I'm sorry.
Gotta love experts.
Well, I'm not used to it. I know everyone uses Zoom. We don't actually use it in my job, so I'm not as good at Zoom as I am at some of the other programs.
Use like Microsoft Teams, or what program do they have you using?
WebEx.
Oh, wow. I haven't heard of that one.
Right. Let's see. I see Mr. Nibbs. I see Ms. Chandler. I see all 4 advocates. Are we ready to proceed then?
Yes, Your Honor.
Yes, Your Honor.
All right, great. Are there any motions for either party before we proceed with the defense's case?
Yes, Your Honor. Pursuant to Rule 50A, we move for directed verdict. Even viewing the evidence in the light most favorable to the plaintiff, they have failed to make a prima facie case for wrongful death. First, they haven't even shown that Lou Donaldson is dead. Plaintiff has not brought a death certificate, autopsy report, a body, or any forensic evidence showing Mr. Donaldson is dead. Second, they have failed to show that Karen caused his alleged death. Plaintiff has not shown that Ms. Baji had anything to do with the alleged death or his disappearance. The plaintiff himself cannot testify to any observations of Ms. Baji hurting or threatening, Ms. Baji physically assaulting or hurting Lou Donaldson, or any observations from the night of Lou Donaldson's disappearance. Nor did the private investigator bring any inculpatory evidence against Ms. Baji after a 3-year investigation. Thus, directed verdict is unwarranted.
Okay. Response from the plaintiff.
Yes, Your Honor. The jury may consider circumstantial evidence in arriving at their conclusion. Here we have presented evidence, circumstantial evidence, that Lou Donaldson is dead. He was declared legally dead. And further, the Karen Basia caused the death of Lou Donaldson. We have presented circumstantial evidence of the whereabouts of Karen Basia on the nights of August 18th and the morning of August 19th to further go into our theory that she had some intentional or reckless actions that caused the death of Lou Donaldson. And therefore, this directed verdict should be denied.
Okay. Unsurprisingly, I'm going to deny the motion. Defense, please call your first witness.
Yes, Your Honor, we call Ms. Karen Basia. Permission to proceed, Your Honor?
Yes, thank you.
Good evening. Please introduce yourself to the jury.
Hi, my name is Karen Baja.
Ms. Baja, I want to know a bit about your work. Tell us what you do for a living.
I run the Wild Wildlife Big Cat Emporium.
What is that exactly?
It's a sanctuary for all kinds of big cats, like lions and tigers and cougars. We raise and protect the big cats from bad people that just want to exploit them. And we just give them the best life that we possibly can.
How did you come to be involved in this type of work?
My husband, Lou Donaldson, he got me started here. He loved big cats and he introduced me to the work, and soon it became my biggest passion.
Let's talk a bit about your husband. How did you two meet?
Well, I was hitchhiking along a road in Statesville, and it was getting pretty late and I was getting pretty scared. And then Lou came and picked me up.
Tell us more about your relationship after that.
Well, after we spent that first night together, we grew very, very close, and we founded the Emporium together and eventually got married, and we were happily married for many years.
I want to know a little bit more about your husband. What was Lou like?
We loved each other very much. I loved him for introducing me to my passion, but like anyone, he had his quirks.
What were some of these quirks?
He was kind of a secretive guy.
What do you mean by secretive?
Objection, calls for speculation.
Response to that, Mr. Hobbs?
Your Honor, Ms. Baggio, as an offer of proof and outside the presence of the jury, Ms. Baggio only testified to her personal interactions with her husband.
Yeah, I think she can probably, although if it goes too far, you can re-raise your objection. For now, overruled.
Ms. Baggio, what do you mean by secretive?
Well, for one example, he used to kind of disappear and take these unannounced flights, and he would just up and leave in one of his planes. He wouldn't tell me where he was going. He wouldn't tell me when he was coming back or anything.
You said he would take off in one of his planes. Was he a pilot?
Yes, he was.
How much did you know about Lou's flying?
Honestly, not very much. I never knew how many planes he even owned. I had no idea where he kept them.
Besides the secrets, how was life with Lou?
Well, like any marriage, we had our challenges, and as much as I loved him and he loved me, his family never really liked me that much, and that could really put some strife on our relationship at times. And we had a particularly rough patch in June of 2012.
What happened in June 2012?
Well, Lou tried to get a temporary restraining order against me. The court denied it, though.
Now, Ms. Baggio, did you ever threaten Lou before he tried to get this restraining order?
No, absolutely not. We had our fights like any married couple, but I would never actually threaten to harm him.
How was your relationship with Lou after he attempted to get the restraining order?
Well, eventually Lou told me that he had a mistress in Costa Rica, and he told me that he wanted a divorce, but I really thought that we could work through it.
Now, Ms. Baggio, I want to talk about the night of August 18th, 2012. Tell us what you were doing that morning.
Well, I was home for most of the night. It was, I think, a little bit before 3 a.m. that I realized I needed to go to the store to pick up some formula for a new baby cub that we had at the Emporium. So I decided to just take a quick trip to the grocery store that night.
Tell us why you had to go then and there to get this cat formula.
Well, I've been doing this for a while, and these baby cubs are always very, very hungry, and they need to be constantly fed. So I knew that I couldn't just let the little guy starve and wait for me to have a time that was convenient for me to go to the store.
What happened after you got to the store?
Well, I went and I got the formula, and then I got in my car to leave to go back to the Emporium. And then it all of a sudden broke down. So I flagged down a car and asked to borrow their phone. And I called my brother, Carl Bannister, because I knew he'd be around. And I asked him to come pick me up.
How did you know he would be around?
Well, he's a deputy sheriff with Pioneer County, and he was on call in the area that night. Plus, Carl's always been there for me, so I knew that he'd be able to come pick me up.
What happened after your brother picked you up?
He took me back to the Emporium, and then I went and fed the baby kitten.
Did you see your husband at all that morning?
No, I did not.
Did you see him at all that day?
No, I did not.
How did you react to not seeing your husband?
Honestly, at the time, I didn't think anything of it. He always kind of disappeared off to unknown places, so I kind of figured like that this time was like any other.
Ms. Baggio, when did you next see your husband?
Unfortunately, I didn't. I never saw or heard from Lou again.
I want to talk about something that was brought up in the plaintiff's case. Were you in the courtroom when the plaintiff made the statement of you claiming Lou's life insurance plan?
Yes, I was.
Explain to us why you needed to make that claim.
Well, by the time I made the claim, it had been 5 years, and I needed some closure. Plus, I was running the Emporium all by myself, and I needed some support to keep Lou's dreams alive. And, you know, running it by myself and without any money made it incredibly difficult. So making the claim was the only way I could ensure that I could keep the Emporium going.
Ms. Baggio, were you in the courtroom when the plaintiff showed Exotic Bob's testimony?
Yes, I was.
Did you ever make those threats to Exotic Bob?
No, I did not.
Did you ever have a conspiracy with Exotic Bob to import big cats?
No, I did not.
What was your relationship with Exotic Bob?
I mean, really not good at all. He's an animal exploiting con artist, and I had his little operation shut down.
I'm sorry, was that an objection? I didn't hear it.
Yes, Your Honor. Objection to improper character evidence.
Response to that, Mr. Hobbs?
Your Honor, this is permissible character evidence under 405. Ms. Paglia is speaking to Exotic Bob's reputation and is not being used for propensity purposes as pursuant to 404.
Any response to that, Mr. Bauer?
Yes, Your Honor. I think opposing counsel said it was towards Exotic Bob's reputation, and I believe it should be reputation in the community, not just reputation between Exotic Bob and Karen Basia and her personal thoughts and beliefs.
I think 405A allows it to be in the form of an opinion, but cannot utilize specific instances of conduct unless you wanted to on cross-examination, Mr. Bauer. I'm going to overrule, but I'm not going to allow any further testimony on the issue.
To clarify, Your Honor, no further testimony on Exotic Bob?
On specifically her opinion of what she just stated about his, him being an exploiting animal. I can't remember her exact words.
Yes, Your Honor. Ms. Paglia, why did you shut down his zoo?
Because it wasn't really a zoo. It was more of a prison for those poor big cats, and he only kept those cats so he could sell them.
How did you shut down this operation?
I filed a civil suit against him, and I eventually got all of his cats. And the civil suit opened up a bigger investigation, and that led to Exotic Bob being locked up.
Ms. Paglia, do you know what happened to your husband?
I honestly don't know.
Did you ever threaten to kill him?
No, I did not.
Sorry to ask, but did you kill your husband, Lou Donaldson?
No, I did not.
No further questions, Your Honor.
All right, cross-examination.
Yes, Your Honor. One moment to prepare my screen. Ms. Basia, your marriage was rocky.
Yes, most marriages are rocky.
Had its ups and its downs.
Yes, it did.
And there was a point where you and Lou started fighting.
Yes.
Fighting a lot.
Yes.
And Lou attempted to file a restraining order against you.
Yes, that's correct.
Your Honor, permission to republish Exhibit 16?
That's fine.
Your Honor, are you able to see my screen?
Yes.
This request states that Lou did not feel safe around you.
Yes, that's what it says.
And this request states that you threatened to kill your husband, Lou Donaldson.
Yes, that's what this says.
And the request states that Lou Donaldson was seeking a divorce from you, correct?
Yes, that's correct.
Ms. Basia, Wild Wildlife has big cats.
Yes.
Like lions.
Yes.
Tigers.
Yes.
Leopards.
Yes.
These animals live at Wild Wildlife.
Yes.
And because they live there, you feed them.
Yes.
And in order to feed these animals, you have a meat grinder at Wild Wildlife.
Yes, the Emporium has a meat grinder.
Objection, Your Honor.
What's the basis?
Outside the presence of the jury, we anticipate that plaintiff is going into the territory of eliciting testimony about a meat grinder to speculate that Ms. Paglia put her husband through a meat grinder. This testimony is baseless in a conclusory statement and is substantially more prejudicial than is probative under 443, excuse me.
Response to that, Mr. Bauer?
Yes, Your Honor. We only intend to enter in the meat grinder and ask about how big the meat grinder was and how many people it took to use the meat grinder, as this is something that Ms. Basia has knowledge of.
And what's the relevance of that?
Your Honor, it is a theory that Ms. Messia put her husband through the meat grinder as supported by the testimony of Exotic Bob, who he states that, I'll feed you to the kitties just like I did my husband.
I'm going to allow it for that reason, then overruled.
Now, Ms. Donaldson, if you could look at what has been marked as Exhibit 0011, which is on page 49 of the trial packet.
Okay.
You recognize this?
Yes.
You recognize this because you've seen it before.
Yes, that's correct.
And this is a picture of the meat grinder at Wild Wildlife.
Yes, that's correct.
This is a fair and accurate representation of the meat grinder at Wild Wildlife.
Yes.
Your Honor, plaintiff moves what has been marked as Exhibit 0011 into evidence as as Exhibit 11.
And Mr. Hobbs, I'm sure you object for the same grounds as you did before. Is there anything else other than 403 that I previously overruled, noting, I assume, again, the same objection?
403, and also, Your Honor, this is not relevant to the case under the grounds which plaintiff is trying to enter it in. The fact that Ms. Baja has a meat grinder, it has no bearing on this case outside of any sort of prejudicial effect they hope it to have on the jury.
Your Honor, may I respond?
Sure.
On the direct examination of Ms. Baja, it was elaborated into how caring Ms. Baja is and how much she cares for these animals and feeds the baby kitties formula. We are simply going into more operations at Wild Wildlife and the tools that are available to Ms. Messia's disposal.
Well, I'm not really sure the details of how the animals are cared for at Wild Wildlife is relevant. I frankly don't see what that has anything to do with a wrongful death suit. Now, I agree with your first assertion that if it is the plaintiff's theory that she disposed of the body from this, I will allow that for that reason. But this is not a trial about the day-to-day operations at a facility. So what purpose is it being used for, Mr. Bauer?
It is being used as a theory of how Karen Messia killed her husband, Lou Donaldson.
I will allow it for that purpose. But I don't want to spend a lot of time on this for the reason I just stated for operations or anything like that.
Understood, Your Honor. I have two questions left to wrap this up. Permission to share Exhibit 11 and publish with the jury?
Yeah, it's admitted. Go ahead.
Ms. Messia, if you could look at Exhibit 11, this is a big machine.
Yes.
So big that it takes two people to use this machine.
Yes, that's correct.
No, I'm going to switch gears. On the night of August 18th or morning of August 18th, your car broke down.
Yes.
You needed help.
Yes.
And at that point, you were still married to Lou Donaldson.
Yes.
A man who you loved.
Yes.
Your best friend.
Yes.
But you called you called your brother Carl Bannister for help that night, correct?
Yes, that's correct.
And the next morning after your car breaking down and not knowing where Lou Donaldson was, on August 19th, you went to Wild Wildlife.
Yes.
And you said it was normal for Lou to up and leave and you not know where he was, correct?
Yes, that's correct. Yes.
And you further said that you didn't think anything strange when Lou would disappear days at a time.
Yes.
No. You went to Wild Wildlife that morning to get Lou's will.
No.
You left Wild Wildlife with that will?
No.
No. When you were at Wild Wildlife, you talked to the police that morning.
Yes.
And you told the police that you were the owner of Wild Wildlife.
Yes.
Ms. Messia, you are a co-founder, correct?
Yes.
And as a co-founder, does that allow you to lie to the police and tell them that you're an owner?
Objection, Your Honor. Argumentative.
Sustained. You can rephrase.
Yes. You lied to the police that day when you told them you were an owner.
Yes, I guess so.
You guess so. So you guess so that you lied to the police that morning at Wild Wildlife.
Objection, Your Honor. Asked and answered.
Sustained.
Ms. Messia, your husband had a life insurance policy.
Yes, that's correct.
That policy was worth $5 million.
Yes.
And you were the one that had your husband declared legally dead, correct?
Yes, that's correct.
And on that same day, you filed for the proceeds of the life insurance policy.
Yes, that's correct.
You were so excited to get that money that you couldn't wait.
I wouldn't say I was excited to get the money. I needed it.
No further questions.
All right, any redirect, Mr. Hobbs?
No, Your Honor.
All right. Any additional witnesses for the defense?
Yes, Your Honor. Yes, Your Honor. The defense calls Chris Renard.
All right.
Permission.
Apologies, Your Honor. Excuse me, we requested a time check.
Oh, I'm sorry. I was going to do that before we began. That's correct. Do we have a witness available that is doing timekeeping that can let us know where we're at, please?
Yes, I'm doing the timekeeping. Sorry, the objections, I want to fully disclose there's a couple where I tried to restart my timer and I missed it. Sorry, you were asking for how long each team has remaining of their 70 minutes.
Or you can tell us how much they've used so you don't have to do that math. That's fine.
Okay. I believe 12 minutes is left for what team is Pikes Peak team. Hold on, let me change my timer to the other view. And 40 something, 47, I believe.
Do we have anybody else who's also keeping time that we can compare? I just want to make sure that's.
I kept time for the plaintiff's team, and I had that they had used 46 minutes.
And how much time do they have available total?
70.
Okay, those are big differences. Hold on.
Sorry, maybe I had the 47 was the, hold on.
Your Honor, are objections counted towards the time, or is the clock stopped? That is something.
The clock is supposed to stop on objections was the rules that I was told.
Yep.
Understood.
How much time, Ms. Pride, did Pikes Peak utilize?
46 minutes.
Okay. So plaintiff has 20, we'll go with that. I'm going to be generous just in case. And
I'm sorry, one more time. How much time does the defense have left?
we heard 40 minutes left. That seems like maybe a little bit too much. But I don't know what else to do. I'm sorry. Was anyone else keeping time for the defense?
No, Your Honor.
That's fine. So we'll go ahead and give Pikes Peak 24 minutes. Mount Cameron, I'll go ahead and say that you do have the remaining 40 minutes. I'm going to urge you not to use 40 minutes for one cross and one closing. I'm also going to ask, I'm sorry that Ms. Dobbins, we should have clarified who was keeping score for each side. I know it's harder to keep for both. You can just keep track of Mount Cameron going forward. But again, I don't think time's going to be an issue for them. So don't worry about it too much. Is that okay? Are you okay, Ms. Dobbins? You're muted here.
So I will start that at 24 minutes countdown starting now.
Nope. I'm just, you know what? I'm just going to keep, since you've got a witness, Miss Pride, I'm going to put you in charge of time for the rest. Okay.
Okay.
And we've got 24 minutes for Pikes Peak and Mount Cameron has 40 minutes. So I'm not really concerned about the time on Mount Cameron, but can you keep for both I mean, there's only one witness and closings left. So you good? You're muted, Miss Pride, but I trust you're good.
I'm good.
Cool. Okay. With that, defense, please call your next witness, which I think you've done, but do it again just so we know who we're talking to.
Yes, Your Honor. The defense calls Chris Renard.
Thank you.
Permission to proceed.
Yes, go ahead.
Good evening. Please introduce yourself to the jury.
Good evening. My name is Chris Renard.
Let's talk about your education. Where'd you go to school?
I received my bachelor's in arts in criminology from Summit College, and then I also attended the police academy.
Where do you work now?
Currently, I work at Summit Life Insurance.
How long have you worked there?
20 years.
What is it exactly you do for Summit Life Insurance?
I work as an insurance investigator and as a forensic document examiner.
What does this mean?
So typically Summit Life Insurance will assign me to look into a death or a disappearance. So I gather information and try and figure out what happened, kind of like a private detective.
What was your role in this case here today?
I conducted an investigation for Summit Life Insurance in regard to Mr. Donaldson's case, as well. Included in that was a comparison of the will of Mr. Donaldson.
To be clear, were you hired by one of the parties here today to distill the facts in this case?
No, I was hired by my employer, Summit Life Insurance.
So why is it exactly you're asked to conduct these investigations?
So when a court declares someone dead, as in the case of Mr. Donaldson, there's a big life insurance payout. But if the beneficiary of that payment caused the death in question, then my employer doesn't have an obligation to make that payout. So Summit, my employer, basically needs to conduct an investigation to see if there is any foul play. It's very standard for this type of claim.
You mentioned foul play. What do you mean by foul play?
So my job is to see if there's a reasonable basis to deny that claim, that insurance payout that I was referring to. So in this case, I had to determine whether or not Ms. Basia had anything to do with Mr. Donaldson's disappearance.
How many years of experience do you have at investigating insurance claims?
20 years.
How many years of experience do you have as a forensic document examiner?
Around 23 years.
Now, you mentioned that you conducted an investigation and then a signature comparison. Let's talk about your investigation first. Tell us how you conduct your investigation.
I try and compile all the facts that I can about the whereabouts of Mr. Donaldson.
What facts were those?
Well, first, kind of most obviously, the last time that he was seen, which was August 17th, 2012. And then he was legally declared dead, as has been mentioned, 5 years later on August 18th, 2017.
With this information, what were your next steps?
Next, I had to determine where Mr. Donaldson was or could be during this time. So I contacted the sheriff's department and I spoke with all of Mr. Donaldson's friends and family and associates.
Your Honor, outside the presence of the jury, this was argued in motions to limine. She, however, is not going to go into the conversation she had. I'm just going to ask her, after speaking to them, what was her next step. I just wanted this to be clear.
And this is the this is about whether or not there was any foul play according to the sheriff's office. Is that right?
She's not even going to testify to what the sheriff's office or these people said.
Okay. I do think, all right, that's fine. Go ahead.
All right. Now, Ms. Renard, after speaking with these parties, what did you do?
Based off, generally speaking with these parties, I told my employer, Summit Life Insurance, to pay the claim to Ms. Basia because I didn't find any sufficient evidence to tie her to Mr. Donaldson's disappearance.
Now I want to talk to you about the documents you examined in this case. What does it mean? Oh, can you tell the jury what it means to be a forensic document examiner?
Kind of what it sounds like. I examine official documents and I basically am trying to figure out whether or not they were forged.
How does one go about doing that?
Well, first I have to just obtain the document. So in this case, the document in question was the will.
Ms. Renard, have you received any certifications in this field?
Objection, leading.
Overruled. It's foundation.
Yeah, I have received certifications in the field by the Board of Forensic Document Examiners, and then also by the Association of Certified Fraud Specialists.
What about trainings?
I participate annually in training workshops, and then I also take part in continuing education related to the field of forensic documentation. Yeah.
Without telling us your opinion just yet, did you come to a conclusion in this case?
I did come to a conclusion.
What is it that you relied on when coming to this conclusion?
I relied on the evidence provided to me from both parties.
Objection, Your Honor. The witness hasn't been tendered as an expert in the field of forensic document examination. She's talking about what she relied on as an expert.
I think that stating that she's relying on scientific principles is laying foundation pursuant to 702. So I'll go ahead and allow her to answer. Overruled.
Mr. Nard, I'll ask again. What did you rely on when coming to your conclusion?
I relied on the evidence provided to me from both parties, the will in question and the multiple signatures.
Are these the types of facts and data that other experts in your field would use?
Yes, certainly.
When reviewing these documents, did you apply a series of reliable methods that other experts in your field would use?
Yes.
Now, did you reach your conclusion to a reasonable degree of professional certainty?
Yes, I did.
Your Honor, pursuant to the witness's testimony and Federal Rules of Evidence 702, I offer this witness as an expert in forensic document examination.
Any objection or voir dire, Ms. Fellows?
No, Your Honor.
Okay. She shall be recognized by the court as such. You may proceed.
Yes, Your Honor. Once you had these documents in question, what were your next steps?
Next, I had to compare the known signatures of Mr. Donaldson to the signature on the disputed will.
Did you have other known signatures?
Yeah, I had two other known signatures. One came from his state-issued driver's license, and then the other was from some paperwork that Mr. Donaldson signed with my employer.
Now, with these documents, what are your next steps?
Well, I reviewed the signature on the will and then compared them to the two known samples.
Marking for identification, this report that can be found on page 40 of the record, it has a Bates number ending in 007 as defense A for identification.
Okay. And what was the pre-marked number, please?
It's a Bates number ending in 007, Your Honor.
I'm sorry. And was that is it a pre-marked exhibit? I apologize.
Yes, just with the Bates number.
Your Honor, this evidence was already admitted as Plaintiff's Exhibit 7.
Well, either way, admitted then.
Ms. Renard, do you have this report in front of you?
Yes, let me pull up the page. Yes.
Do you recognize it?
Yes, I do.
How do you recognize it?
This is the report that I produced.
Is it a fair and accurate depiction of the report you produced?
Yes.
Defense moves what has been marked for identification as defense A into evidence as defense A in evidence.
Any objection or voir dire, Ms. Fellows?
No, Your Honor. I mean, this evidence has already been admitted. Objection.
So I'm confused. Is this are we admitting her report, Mr. Nunez?
It's simply the signature comparison, Your Honor. And
I'm sorry.
No, it's fine. And the words below it have been redacted and opposing counsel has seen the redactions.
Okay. Yeah, I think this is in evidence. So we can admit it as defense A as well, or it's in evidence as Exhibit 7. So you may proceed.
Now, Ms. Renard, when comparing the signatures, what did you see?
As you can see here, there are some similarities and then there are some differences, but my findings are inconclusive at best.
What do you mean by inconclusive?
It means that it's possible, but very unlikely that someone tried to copy Mr. Donaldson's signature.
What are the similarities in the signature, if there are any?
There are similarities, particularly in regard to loops, stroke direction, curves, legibility, angles, embellishment, capitalization of letters, as you can see here before you.
What are the differences you see, if any?
Well, once again, as you can see, their signatures are not exactly the same.
What are some reasons that signatures might not be the same?
There are a lot of reasons why two signatures aren't going to be exactly the same. A signature may change as a result of age as someone gets older, health, even just the care that they took when signing their signature on two separate occasions, the writing instrument, the pen that they were using when signing, or simply that just the signee wanted their signature to look different.
If a signature is different based on these reasons you listed, what characterizations might you see in the signature?
Some common ones are like shakiness or tremor.
I think there was an objection, Your Honor.
Objection leading, Your Honor.
I don't think it was leading. It didn't suggest the answer, so overrule.
Ms. Renard, I'll ask again. Based on the differences you mentioned, what are characteristics you could see in a signature?
You'll often see tremors, some shakiness, or just kind of overall sloppiness or carelessness.
With this knowledge, how did it impact your conclusion?
Well, I can't conclude that the signature on the will was forged.
Can you explain to us why that is?
Well, even though there are some differences on the signature, Mr. Donaldson could have just gotten older, sloppy, and I didn't really see a cause for concern because I saw just as many, if not more, similarities between the two.
What were the results of your analysis of the signature that you provided to Summit Life Insurance?
That there was not enough evidence to claim that Ms. Basia forged his will, and I recommended they pay Ms. Basia the $5 million.
Thank you. No further questions at this time, Your Honor.
All right, cross-examination.
Ms. Renard, when you first investigated this case, you tried to speak to the police, right?
Yes, I attempted to.
But they refused to give you any information.
Yes, they said the investigation was still ongoing.
Right, so you didn't see any physical evidence from the police, did you?
No.
Now, you also looked into Lou Donaldson's bank account.
I did.
His only bank account.
Yes, the only one I'm aware of.
And you saw that there was no transactions a week after August 17th, 2012. Correct?
No transaction.
A month after August 17th, 2012.
I saw no transactions at any point.
Right now, you're a forensic document examiner, correct?
I am.
You analyze signatures and documents for their authenticity?
Yes.
And you specialize in signature and handwriting identification?
Yes.
Now, your findings here, they were inconclusive, right?
Correct.
And because they were inconclusive, you can't tell us whether the signature on the will is in fact Lou Donaldson's.
Correct.
In fact, you say it's possible that someone did try to copy Lou Donaldson's signature, correct?
Yes, that is possible.
Now, Ms. Renard, you can't tell us whether the signature on the will is genuine or non-genuine.
Correct.
Now, you mentioned that there was just enough differences as there were similarities, right?
I said there are similarities and differences. I found more similarities than differences.
Right, and then you also said that it appeared to be Lou Donaldson's signature, correct?
Correct. My findings were inconclusive, so.
But appears doesn't mean 100% that it is Lou Donaldson's signature, does it, Ms. Renard?
It does not.
Thank you. No further questions.
Any redirects?
Excuse me, Your Honor, no.
Okay. Thank you, Ms. Renard. Any additional witnesses for the defense?
No, Your Honor, the defense rests.
Okay. I assume that you would renew your motion, and I will deny that as well, so I won't have you all recite it again. Everyone did a very nice job. That went relatively quickly, so we can get a time check before closing. So I imagine most people are probably all right on time. Miss Pride, how much time did Pikes Peak use?
Give me just 1 second to add this.
While she's doing that, is anyone requesting, including our jurors, a break before we move to closings, or are people okay to continue forward?
I'm ready to proceed, Your Honor.
For defense?
That's fine for us.
Our jurors okay?
Yes, Your Honor.
Great.
Defense has used 53 minutes, or the plaintiff, sorry.
That's fine. I'm not.
Yeah, and the defense has over a bunch of time left, so I don't have like the exact calculation on that.
Okay. I would guess they're around 30 minutes. So 17 minutes for defense or for plaintiff, and more than enough time for defense. Does anyone have any issues with time, or are we okay? I know there's a little confusion. I don't want anyone to be upset about that.
No, Your Honor.
All right. With that, I will turn to the plaintiff for closing argument.
Yes, Your Honor, and I'd also like to save a few minutes for rebuttal.
That's fine.
Patient like a tiger, the defendant stalked her prey and waited for the kill. She waited 5 years to get Lou Donaldson's money. August 17th, 2012, that's the last time anyone sees Lou Donaldson alive, because the defendant killed him just to get what she wanted, not to fully understand why she did it. Let me take you back to where it all began. The defendant and Lou Donaldson meet when she's in one of the worst positions of her life. She's young, alone, has nothing to her name until one night, while hitchhiking the streets, Lou Donaldson sees her and he offers her a ride. And the defendant sees her perfect Prince Charming, her lottery ticket out into a new world. The defendant knows that if she goes for Lou, an intelligent entrepreneur, that she will have a life that she never thought was possible. So she captures him and the two get married. Everything is going great for years. The defendant's living a life filled with lions, leopards, tigers. But it all comes scrambling down in June of 2012 when Lou threatens to divorce her. Now, the defendant doesn't want this. If she can't have Lou Donaldson, nobody will. If she can't have the Wild Wild Life property, nobody will. Scared for his life, Lou Donaldson goes to court and files a restraining order on June 12, 2012. And the very next day, members of the jury, just 2 days later, the defendant changes his will to give herself everything. June 14th, 2012. And then she kills him. That is a story that brings us here today. Today we had a burden to prove this case by the preponderance of the evidence. Members of the jury, all that means is that we had to show, it's more likely than not, that Lou Donaldson is dead, that the defendant killed him, and that Cam Donaldson is suffering because of it. We've met that burden. The exhibits and the testimony that you saw and heard today prove just that. Let's talk about it. The defendant had this all figured out, members of the jury. She changed Lou Donaldson's will. She'd kill Lou Donaldson. She would take over the Wild Wild Life property, and then she would get rid of Cam. We know that she forged Lou Donaldson's will because Taylor Pride, the forensic document examiner, with over 18 years of experience, came onto this trial and told us each and every step that she took in analyzing Lou Donaldson's sample signatures and comparing it to the signature on the will. Collect, analyze, compare. Let's take a look at the signatures that Taylor Pride analyzed. Taylor Pride analyzed the signature from the temporary restraining order and the signature from Lou Donaldson's driver's license. Taylor Pride gave us details, members of the jury. She talked about each characteristics in the letter, the lazy O in Donaldson, the small tail embellishment in the U, the loops and the L's, but the most striking thing that Taylor Pride found, members of the jury, was that the writer of those two signatures rarely lifted the pen. Let's take a look at the signature that the defendant expects you to believe is Lou Donaldson's. Members of the jury, Taylor Pride testified that this signature was filled with quivering lines, and that quivering lines meant that the person was hesitant, nervous, as if to copy someone else's signature. The defendant was nervous. The defendant hesitated. But she forged Lou Donaldson's will just to get control of Wild Wild Life. Now, Chris Renard, the Summit Life Insurance Company forensic document examiner, also analyzed signatures. He analyzed the signature from the life insurance policy and the signature from Lou Donaldson's driver's license. But when he compared those signatures to the signature on the will, all he did was sufficient similarities, no reason to contest payment. Chris Renard didn't give us details of the differences that she found. Chris Renard didn't give us details about the similarities she found in the sample signatures. Chris Renard's examination was weak like a tiger's prey, and she fell for the defendant's trap, members of the jury. Taylor Pride testified to one very important thing, and that's that he found it suspicious that the language on the will said, "Should I die or disappear?" Should I die or disappear? Members of the jury, the defendant killed Lou Donaldson, and we know how she did it. The defendant came onto this trial, and she talked about the early morning of August 18th, 2012, and how she had to go to the grocery store at 3 a.m. to grab milk. And on her way back to the Wild Wild Life property, her car breaks down. Now, rather than call her perfect Prince Charming, the love of her life, her best friend, the defendant calls her brother, Carl Bannister. Now, we know that Carl Bannister is a police officer in the state of Statesville. And we know through his testimony that every single police cruiser within the borders of Statesville has a tracker. Members of the jury, Carl Bannister's tracker indicated that between 3:20 a.m. to 6:30 a.m., he was near the grocery store for 3 hours.
Your Honor, I usually don't do this objecting on closing. This is, she's closing on something that never made it into evidence.
The jury will be instructed that closing arguments are not evidence, and they should not be considered as evidence. And I think that'll be sufficient.
Your Honor, also quickly, this information was read during the plaintiff's case in chief through the deposition.
I overruled anyway. The jury's instructed that they're only to consider evidence and closing is not evidence. Thank you.
Members of the jury, between 3:20 a.m. and 6:30 a.m., Carl Bannister's tracker indicated that he was near the grocery store. But he claims that he went to the grocery store, picked up his sister, and the both of them went off in his police cruiser back to the Wild Wild Life property. Members of the jury, that's not what happened. What happened was that Carl Bannister went to the grocery store to create this alibi for his sister. And the both of them got in the defendant's car and rode off to Wild Wild Life to finish Lou. We know it takes two people to work the meat grinder at Wild Wild Life, Carl Bannister and the defendant, and they have 3 hours unaccounted for, members of the jury. 3 hours to load a body, stick it in the meat grinder, and feed the cats. And the very next day, members of the jury, the very next day, August 19th, 2012, around 6 a.m. The defendant is caught leaving the Wild Wildlife property with an unnamed person, and that unnamed person was holding a lock cutter. And when the police asked her what she was doing there, the defendant claimed that she was an owner. Members of the jury, we didn't lose our common sense when we zoomed into this trial. An owner wouldn't have to use a lock cutter to get onto the property. An owner would have a key to get into the property. And the defendant admitted it. She lied to the police because in fact, she wasn't an owner. She was a co-founder. That's two different things, members of the jury. She killed him. But unlike a tiger, she wasn't quiet about it. She admitted it. She admitted it to Exotic Bob after the fact by threatening to kill Exotic Bob the exact same way she killed her husband, by feeding him to the cats. Members of the jury, we know that Exotic Bob and the defendant, they aren't the best of friends, but it's your job and your responsibility alone to test the credibility of each and every witness. And in doing so, you could think about the way they speak, the way they dress, the way they sing, the motives behind testifying. Members of the jury, Exotic Bob is sitting in a federal maximum security prison cell, and his music video isn't going to change that. Exotic Bob has no reason to lie to us. It's been 5 years. 5 years of no calls, no signs, no letters from Lou Donaldson. From one day to the next, Lou Donaldson disappeared without a trace, almost $100,000 sitting in his bank account, untouched. The last transaction on that bank record was August 17, 2012. No transaction a week after, a month after, a year after. Yet the defendant expects you to believe that Lou Donaldson flew 2,200 miles without spending a single dime. Members of the jury, that doesn't make any sense. If Lou Donaldson were alive, that money wouldn't be sitting there collecting interest. That money would have been used. Now, was that because he left his wallet the same way that he left his glasses? Lou Donaldson's glasses were found at an airstrip 40 miles away, an airstrip that he never flew out of. And we know through Cam Donaldson that her dad was as blind as a bat, and that pair of glasses was the same pair that he had since she was in high school, his only pair. Yet the defendant expects you to believe that Lou Donaldson flew 2,200 miles overseas alone without his glasses. That doesn't make any sense. And what also doesn't make any sense is that Taylor Pride sent an employee to Costa Rica, and that employee didn't find a single trace of Lou Donaldson. Members of the jury, of course he didn't. That's because Lou Donaldson never left the borders of Statesville. Lou Donaldson was stuck in a meat grinder and fed to the cats at the Wild Wildlife property. Now, we also had to prove that Cam Donaldson suffered injuries. Losing her dad alone was devastating, but losing her dad because the defendant killed him is crippling. Lou Donaldson was a present and caring father. He took Cam under his wing and showed her the ropes at Wild Wildlife, and that's why she dedicated 20 years of her life to that cat sanctuary. 20 years. Every day, Cam Donaldson wakes up knowing that she will never be able to go back to the Wild Wildlife property, knowing that she will never be able to look her father in the eyes again. And all of this is because of the defendant, because the moment that the defendant gained control of Wild Wildlife, she got rid of Cam Donaldson like a piece of trash. Members of the jury, Today, you'll receive a verdict form. Go out into a breakout room and deliberate. And we ask you that in assessing damages, you think about the fact that Cam Donaldson lost her father, her best friend, her mentor. Today, we ask that you give a verdict of $10 million to Cam Donaldson. Now, no amount of money will bring Lou Donaldson back, but $10 million will give Cam Donaldson what she lost because of the defendant. $10 million will give Cam Donaldson what she deserves. We've met our burden by the preponderance of the evidence, members of the jury, and we ask you to come to the right conclusion here, that Lou Donaldson is dead, that the defendant killed him, and that Cam is suffering because of it. Don't let the defendant trick you, members of the jury. Don't be a prey. Thank you.
Thank you, Ms. Veloz. Closing from defense.
Yes, Your Honor. Just briefly, outside the presence of the jury, just want to renew my objection in motions limine. There was an argument regarding Exotic Bob's testimony, and they brought it through with regards to against his penal interest, and then in closing argued that he had nothing to lose. I just want the record to be clear, should there be a potential appeal.
Okay, noted.
All right, one moment to set up my camera. Permission to proceed.
Go ahead, thank you.
I want to make this very clear. No body, no proof, no liability. Now, the burden of proof rests with the plaintiff, and it is called a burden for a reason. When the plaintiff drags a citizen of our state into court and alleges that she caused someone's death, it is their job to meet that burden. Today, the plaintiff had to prove to you that it was more likely than not that Lou Donaldson is dead, and he is dead because of a wrongful act caused by Karen Baja. They had to prove that their theory was the most likely outcome. They failed. And members of the jury, they failed from the very start. The plaintiff has failed to prove to you that Lou Donaldson is actually dead. Based on what the plaintiff brought you today, we have no idea what happened to Lou Donaldson. He could have just disappeared. Ms. Baja is not a killer because she asked the court to declare Lou dead after 5 years. Having someone declared dead is so different than actually being dead. There's no body. There's no death certificate. There's no autopsy report, no tombstone in the ground. Had the plaintiff had any of this, they would have been waving it to you in front of your face this entire trial. Think about it. Lou Donaldson had the means to leave and disappear at any moment. He left his family once before with no problem when he met Ms. Baja. In fact, the plaintiff had to take the stand and admit to you that Lou Donaldson would disappear and fly in secret so no one could track him. And speaking of means, Lou Donaldson had money, the kind of money that someone could use to disappear and never be found. For all we know, Mr. Donaldson had multiple bank accounts or a secret stash that only he could access. Let's be honest. Lou Donaldson, with all his secrets, is a money under the mattress kind of guy. And the plaintiff, they failed to show you otherwise. Now, the plaintiff brought you Taylor Pride to try and help prove Lou Donaldson's death. But I know you remember my co-counsel's cross-examination. After 3 years of investigation, what would you expect to see? And I wrote this down because it's important. You would expect to see security footage from the airstrip where Lou Donaldson was last found, a death certificate, reports of visits to the morgues and hospitals, interviews with family, friends, employees, or anybody at the airstrip. How about an attempt to trace Lou Donaldson's steps on the night he vanished? Plaintiff's expert didn't bring you any of that. And that right there, that's unacceptable. She admitted, had she done these things, it could have affected her opinion. Plaintiff's expert is either an awful investigator and forgot to do these simple steps, or she did do them. And the results just didn't favor her client. You heard her on the stand. She said it herself. Her and the plaintiff, they forged a bond. And she wanted to maintain that bond. And that explains why on direct, it was so smooth. And the minute she got up on the stand and was cross-examined by my partner, she got so difficult and couldn't answer any simple questions. Either way, the plaintiff, they failed to meet their burden. Now, the plaintiff who hired Taylor Pride, Karen Baja, hates Karen Baja. She hopes that Karen Baja would get eaten by one of her tigers. Yet, even despite this hate, the plaintiff couldn't provide you with proof that Karen killed Lou Donaldson, and that's because none exists. And that's why the plaintiff has failed to prove that Lou Donaldson is dead. Now, let's just entertain that thought for a second. Even if you believe that Lou Donaldson is dead, the plaintiff's case still fails. They couldn't bring you one piece of evidence connecting Miss Baja to Lou Donaldson's disappearance. They brought you a temporary restraining order. That proves nothing. Look at the text of that TRO. There are no details outlining any single one of those claims. All that evidence shows you is that Lou Donaldson is unpredictable. It makes sense that he might request a temporary restraining order one day and then compose a will a few days later, making that person the sole beneficiary. And yes, like husband and wife, Lou Donaldson and Karen Baja fought. Yes, he asked for a divorce. And yes, he filed a TRO, but he filed the TRO and asked for a divorce in the heat of the moment. And we know that wasn't serious because the plaintiff had to concede that Mr. Donaldson went home to his wife every night after that TRO was denied. Had Lou Donaldson feared his wife, he would have found a new place to live. He would have rented a hotel room. He would have stayed with his son. He would have, in fact, filed for a divorce in those 2 months after he filed that TRO. But he didn't, and that supports Ms. Baja's testimony that she and Mr. Donaldson were working through their issues. Next, the plaintiff wants you to believe that Karen Baja is a killer because of words written on a piece of paper. They want you to believe that Karen Baja is a killer because of language in a will. The dire disappear language is there because Lou Donaldson clearly adapted his will to his lifestyle. Think about it. Lou Donaldson would pick up and leave with no notice and fly under the radar across miles and miles of open ocean. He chose this wording because he trusted Ms. Baja to carry out their dream, their shared purpose, the Emporium, just in case one of his trips ended up being his last. And you know what? Lou Donaldson was right because Ms. Baja dedicated her life and her soul into the Emporium and successfully ran it for 5 years. 5 years without any financial support from the estate. Not to mention this wording, it shows that Lou Donaldson was consistent. The plaintiff doesn't dispute that Karen Baja was the only named beneficiary in his life insurance policy. That means he wanted Karen Baja and only Karen Baja to have that $5 million. So it makes sense. It makes perfect sense that he would do the same thing for his will. Now, with regards to Exotic Bob's statement, he's in prison. His statement isn't reliable. You can't trust his word. His statement wasn't made under oath, and it's clearly biased. He treated his statement like a joke, opening and closing with a song. Are you serious? This case, members of the jury, is not a joke. Clearly, he enjoys being in front of the camera. And besides that, he doesn't care what he says. And now the last thing that the plaintiff wants you to concentrate on is the signature comparison done by Taylor Pratt. But let's look at the glaring flaw in that comparison. Taylor Pride had access to a handwritten note by Lou Donaldson, written just 1 month before the will was signed. Miss Pride was on the stand dodging these questions, and that's because that note right there would have given her a lot more to work with than just a few random signatures. Taylor Pride didn't talk about that note in her report. And that's because the writing in that note was probably the most similar to the writing on the will. Members of the jury, don't you want to see that note before you make a decision here today? Of course you do. Now, remember, the defense, we have no burden here today. The burden rests and remains with the plaintiff. However, we did bring you reliable evidence. We brought you Chris Renard, an unbiased expert with no skin in the game. You can trust her opinion because insurance companies, they want to make a profit. They don't want to pay out multi-million-dollar claims. And yet, despite that, Ms. Renard concluded that Ms. Baja was entitled to receive the $5 million payout on Mr. Donaldson's life insurance policy. Her investigation showed no evidence of foul play and that the validity of the will is inconclusive. This means there is no evidence Karen Baja had anything to do with Mr. Donaldson's disappearance. And that right there, that is the key. Lou Donaldson disappeared. We don't know how. We don't know why. But I want you to all think about something. It's late night. And Lou Donaldson, he's awake, thinking about clear blue skies in Costa Rica, a beautiful woman sitting right next to him, and a cigar in his mouth. Then the idea hits him. Life is too short. He has worked hard his entire life, and now he wants to truly live. He has the means to escape. He has planes. He has all the cash. And in this excitement, he grabs his bag, races to his van, and drives to one of his hangars. As he's pulling up to this hangar, the sun is creeping over the horizon, and he starts to rush. He gets the plane off the ground, flies a few hundred miles, and realizes he forgot his glasses. The plane's fuel is low. The engine is sputtering. He's starting to fall from the sky. He can't see a place to land without his glasses, and he crashes. And that is why no one has seen or heard from him, and that's why there is no body, because it's somewhere in the miles and miles of ocean between Statesville and Costa Rica. The plaintiff, cannot disprove this story. They had to. They had to, and they did not. And now, members of the jury, it's your turn. You have the power to tell the plaintiff to prove it. So when plaintiff's counsel gets back up here, challenge her. Ask her for one piece of forensic evidence. Ask her for footage proving that Lou Donaldson never made it on the plane that morning. Ask for a body. Ask for a death certificate. They won't have it. They can't provide it to you. Don't let the plaintiff make this case into the next big true crime story. This is a court of law. We demand facts, we demand evidence, we demand proof. Plaintiff says they have substantial evidence, circumstantial evidence, excuse me, but what they're really asking you to do is to play a game of hopscotch, and they want you to start on 1 and jump all the way to 10. And when you realize that, I'm confident that with no body, no proof, you will find Karen Baja not liable. Thank you.
Thank you, Mr. Nunez. And before Ms. Willows begins, do we know how much time remaining she has?
Yes, she has 3 minutes for rebuttal.
Thank you. Whenever you're ready, Ms. Willows.
Members of the jury, circumstantial evidence is evidence, and the judge will instruct you on that, as it's also in your jury instruction number 10. Now, no proof, no body, no liability. There's no proof, members of the jury, because the defendant covered her tracks. Because the defendant stuck Lou Donaldson in a meat grinder. There's no body for that same exact reason, members of the jury. And for that, there's liability. Now, the defense wants to talk about there's no tombstone. The defendant withheld that from the plaintiff for 5 years. That's why there wasn't a tombstone for 5 years. The defendant also talked about how the note from May of 2012 was so important. Members of the jury, Taylor Pride looked at the temporary restraining order that was filed just 2 days before the alleged will was signed. 2 days, members of the jury. Circumstantial evidence is evidence. Thank you.
Thank you so much. Let's give everyone a round of applause. Nicely done, everybody. Or I'll just clap loudly by myself.
I was trying to unmute.
I'm a little late. I didn't give you any warning. And let's also thank, right? I forgot, yeah. Our wonderful volunteer jurors. Mr. Nibbs, thank you so much for your time.
You're welcome.
Ms. Chandler, thank you for your time as well.
You're welcome.
I believe, and hopefully our scoring jurors have access to this, we actually are not going to give any feedback live. We have sheets that we fill out to send to you. And so if the jurors have any hard time getting into that, it requires this password, and I can send you a private message. I had a little bit of a hard time finding that password and the link. So if you need it, let me know.
Oh, okay, so for scoring and for feedback, there's a link we go to?
Yes.
Oh, okay.
I will get that to you because I had a hard time finding it too.
Oh, then I'll have a real hard time then.
I'll get it for you. And I'll just send you a private message if that's okay. And then I think since we're not doing any feedback, as soon as I get those messages out, you are all free to go. But just a really great job overall. I can't help this. I actually wrote Taylor Pride and I did all the signatures. And so it's funny because the Lou Donaldson's like my real signature. And so I was like making mine. Oh, actually, this is even funnier, just really fast.
Mystery solved.
Mystery solved.
Right now. I had to like practice over and over again to get these things done on like the back of my notes. So I was laughing.
I thought it was too much coffee or something like that. You know?
Well, that could have been part of it.
Maybe.
Do you all have anything for us before I kind of release you? I know it's sort of weird to end on this without being able to shake your hands in person, but you did great.
Thank you.
Thank you.
Thank you. Thank you.
I know I can't give specific feedback, but you all did a great job. You really did. And I learned a lot because we're doing a lot more depositions and court hearings, obviously on Zoom and other mediums. And I learned some things here. So thank you.
Thank you.
Yeah. Have a good night and good luck to all of you.
You too.
Thank you.
Thank you.
Great job.
And Mr. Nibbs, I'm sending you a message right now with the link and the password.
Thank you so much.
Thanks, Mr. Bauer. What kind of law do you practice, sir?
So it's all, right now it's all civil litigation, but I've been a prosecutor, been a defense lawyer, and now kind of back to the civil 0.2s and 0.3s at a time, you know, not digging it that much, but
Okay,
it's all good, you know, employed and it's all good.
very nice.
How
Thanks.
about you? What do you do?
I'm a prosecutor in Adams County.
Oh, that's awesome. I mean, so I was a prosecutor in Cook County for 15 years, like 2 different stints. Best job I ever had.
Really?
I miss it every day. If the right state's attorney got in there and I had a chance to finish up there, I'd probably do it. I mean,
Cool.
great job.
It is
Yeah.
a really fun job.
Oh, that's good.
Yeah, I like it a lot. So I'll be almost 8 years.
Wow. Okay. And then you teach trial advocacy too?
I'm one of the trial team coaches at DU. Mhm.
Yeah. Okay.
So,
So I taught at Loyola Chicago for like 9 years.
wonderful.
Yeah, it was a lot of fun. I miss it actually.
Okay, our paths are somewhat similar then, yeah.
Yeah. Well, pleasure to work with you. You did a great job.
Thanks. Oh man, I felt like I haven't been a ruling judge in a little while. I was feeling a little rusty at first.
Oh no, you're perfect.
Well,
Perfect.
thank you. I think we actually maybe lined up together again at one point. So if I see you again, am I saying correctly, Nibbs?
Yes.
Okay.
Silent K. Yeah, you
Okay.
got it.
Awesome. Well, thank you so much. Have a great evening.
Thank you. You too. Take